Just
Wait, please, Lord. Item number 37, can you adjourn for the day on and any get in the next week, Lord.
37
37, Lord.
bail hearing.
Bail hearing.
Okay.
We have received the case there.
Case there.
Yes.
So are you on interim?
No.
Item number 37. Learned counsel.
Monday or Tuesday, Lord. Make any.
6 an adjournment for the day which is allowed. The case diary received may be retained. It's fixed on, I think Monday is a holiday, so we'll fix it on 27,
Fine.
26,
Lords.
26.
Yes. Obliged. Number of funds.
Mr. Amram. This is on? Yeah.
Item number 6.
Item number
We adjourn for a day, Lord.
item number 6.
6, Lord.
6. Motion. Okay. Lord counsel appearing 6 an adjournment for the day which is allowed. You want any date to be fixed? 26th? Let it be on 27, motion day. Fixed on 27/8/2024.
Obliged.
Lordship, in item number 37, city maker will be retained. Yes, already ordered passed.
Already ordered.
In the city.
Can you switch on the microphone, please?
Only, Lord. Lordship, and they are for listing a heavy lordship, and they are fragments government employee lordship.
Okay.
Section.
Oh, yeah, that's the mention has to be before the senior most criminal bench. So you have to mention before the senior most criminal bench, right?
Okay.
Number 7, Lordship.
Item 7, admission item. Yeah.
28 to 29.
No problem. Your good name, please.
B. Soren.
B. Soren, learned counsel. 6 an adjournment for the day and praise for fixing the matter. Towards the end of next week. Full stop. Fixed on 29th. 29/8.
I will mention item number 28, Lordship. Kindly adjourn for the day, Lordship.
Bail hearing. You're on interim.
Yes, Your
CD has been received.
Customs.
Customs. So we don't know whether CD has been received or not. Learned counsel, your good name, please. N.A. Begum, 6 an adjournment for the date. Also submitting that the petitioner is on interim, is under interim protection. Full stop. The respondent is the standing is the customs department. Full stop. So we can adjourn it, but it'll be better to fix a short date, right? So on Tuesday or Wednesday, next Wednesday. You just inform him, or if you just kindly inform him. Fixed on 27/8. The case diary, if received, shall be retained.
If received.
If received, shall be retained.
Obliged.
Please, Lordship, I'm sorry, Lordship, and as per the roster, Lordship,
Mhm.
the court can be allowed to mention, Lordship. Because yesterday I have approached the senior bench, Lordship. They are not taking the bail, Lordship. So on that basis, Lordship, they are not, Lordship. They have not told, Lordship, motion better.
No, I don't know. I mean,
Motion better, Lordship.
we have to go by the practice direction, right? So that's because I've come new, so we have to go by the practice direction. So if that is the practice that has to be mentioned before senior bench, then it will not be proper for me to entertain. Or you mention it too before the senior bench. Code number 6.
Yesterday I approached, Lordship, but they are not taking the bail, Lordship. That is why not allowed, Lordship. Then those bench are taking bail. You can approach, Lordship. That suggest me, Lordship.
So kindly find out, then you talk to the judicial department, registered judicial. Yeah, at 2 o'clock. Then no, you mention again. And find out the position. Yeah, 14 is also there. 14. the senior most in the order, right?
It is true, Lord, but Lordship,
Ah.
Ablash.
More mention.
NDPS motion BA. It was one.
This is the second application, call for the case date.
Okay. He was arrested on
22,
22/7.
22/7.
You're Mr. Rahman,
M. Rahman.
M. Rahman, learned counsel. For the petitioner, accused was arrested on 22/7/2025. Call for the case diary of Botodroba PS case number 92 of 2025 from the concerned police station. Fix on, any suggested date? 29, 29,
Okay.
2nd September.
Number two.
She regular date application.
Yeah.
So here, page 12 is the affair. For a moment, if Lordship, the gist of the equity
Yeah.
police act.
Let us see.
Yes. May I read the content?
Yeah, you can read.
The complainant begs to state that when the victim's age was 15 years old, studying at class 7 at the time, accused person promised her to make her legally wedded wife and without her consent forcefully took her virginity, and as such she became pregnant. At the time of committing the aforesaid incident, the accused person was residing in the house of the complainant. Thereafter, the accused person lured the victim to took her to Bora nursing home, Vishanacharili, and forced her to abort. And thereafter told her that he would marry her as per Muslim rituals and asked her to stay with her father and mother till then. Thereafter, accused person, without marrying her, married another girl from Vishwanath and started conjugal life. Presently, also he is continuing his marital life. On 26/9/2024, the accused person assured victim to marry her, and yesterday at about 4 p.m., accused person, with the help of family members, assaulted the victim with the help of iron hands and legs at the various parts of the body, causing mental and physical assault. With the help of all the accusation, handed over to Jijia police station at about 10 p.m. The victim presently at Jijia police station. The Jijia police station till now has not intimated the family members of the victim, since the accused person has given assurance of marriage. Therefore, some delay has been occasioned in lodging the instant affair. The witness are ready to testify that this is the affair, Lordship. Assuming Lordship any allegation, then when she was 15, then at the now he happened to be near about 18, and the cracks that is all about that started from 26/9. 26/9, this victim, she entered the house of the petitioner, and petitioner could not register the extent of her atrocity. Finding no other alternative, the petitioner took her to police station and handed over her. And from there only the matter has started, Lordship. This is the crux. So far my understanding goes, no case has been made out. Even then he is inside jail, Lordship. And
He was arrested on 22/7.
he has
We'll have to
Lordship
call-
himself after this
Been summons, he has appeared and thereafter
he has been arrested, Lordship. Now
And
trial has been commenced, Lordship.
Substitute submitted in this case.
Charge sheet submit.
Charge sheet submitted.
So we'll call for the scan copy,
Scan
scan
copy.
TCR, and also
Issue
the notice has to be issued to the informant. Heard T. So, learned counsel for the accused, seeking bail in connection with Jinjia PS case number 80 of 2024. Which after completion of investigation was registered into special POCSO case number 94 of 2024 under section 376 IPC, read with section 6 of the POCSO Act, and stated to be pending in the court of the learned special judge Biswanath. The accused is stated to have been arrested on 22/7/2025. Peruse the Azahar.
Sonari, and he had a grocery shop, Sonari,
And he had a grocery shop in Gangpam village in Nagaland.
Hmm.
Other shop is there and he is running there.
Okay.
Now there is Ejaha law, which your law will find at page 15. This is regarding alpha extortion, my lord. I have nothing to do with this, my lord. And they have arrested 3 persons because no name is there, my lord, so far.
Mhm.
uh,
He's
And-
running a lottery agency,
No,
petition,
grocery shop,
grocery shop,
my lord.
grocery shop.
Gangpam village.
I see.
And now,
I heard it wrongly.
so 3 persons arrested and providing report is at page 17. So are different persons, my lord, regarding alpha, my lord.
Mhm.
Now, I have been arrested, my lord, on the ground that, my lord, I have once contacted one, my lord, Aden Kondak. Aden Kondak is a resident of Jangkam village.
Mhm.
My lord, if you also see the reporting report at page 25. That is in respect of me, my lord. We have given it. Now, the main allegation is at page 27, my lord. It's the only allegation against.
Surajit De.
As per CDI report, the arrested accused persons, Surajit, they have been contacted on so and so. One day, my lord, he has contacted. He is a customer. He is my customer. He is a resident of Eden Kondak. I have stated that. He is a resident of Jangkam village. And he is a customer, my lord. Nothing is there except that, my lord. And this is, the FIR is not regarding NSN, my lord. This is regarding alpha actors, my lord. And my wife is at pregnant stage, my lord, now delivery is on 25th, my lord. That will be in this month, my lord. And my father is also ill, my lord. I have annexed those documents. So this is the sole breadwinner, my lord, he is the my lord person.
It's the, which police station?
Sapekati, my lord.
Tapekati, sir, I do. Get it shortly, Get it on Tuesday or Wednesday. Friday will not be possible, right? Friday will be too early.
From Shivsagar, Sapekati.
So I do.
28 of December.
28. No, why not 27? Motion 27. Heard learned senior counsel GN Sahiba. Stuff. The accused Surajit De, seeking bail hearing, was arrested
On 14/7.
on 14/7/2025 and presently in judicial custody in connection with Sapekhati PS case number 21 of
Yes.
2025. So and so sections. Call for the case diary fixed on 27/8/2025. 27/8. No case diary, it's under investigation.
Maybe your lordship.
Yeah.
The petitioner has been behind the bars for 21 days. He was arrested on 31/7/2025.
31/7.
So the city may be called for.
Okay. UAPA, some.
Yeah.
Okay. Your good name?
Speak out on your lordship.
He heard P. Khatonia, learned counsel for the accused, who fairly submits that at this stage, his diary may be called for. Accordingly, call for the case diary of crime branch PS case number 2 of 25 under section so and so, so and so. The accused Pranab Judy Chetia stated to have been arrested on 31/7/2025. Fixed on
19.
19 1st September. After some time, we take it about.
Not of course.
After some time.
Eventually 45.
Petitioner herein are the managers of the Cholamandalam and Industrial Finance of the company.
Okay.
Petitioner on apprehension filed this specific case, though case is not yet registered in the Satgam police station, but the official of the Satgam police station has visited the office of the finance company and asked the petitioner to be present in the police station. To our best of knowledge and from our inquiry in the CGM 4, we got we did not got any.
Any information. So case probably has not been registered. We will call for a report.
On Friday, can it be on Friday?
Uh,
Sadgaon police station go ahead.
Mr. Neo, heard Mr. P. Neo, learned counsel for the petitioner. First of- It is invoking the provisions of section 482 BNSS. The two petitioners. It is submitted that though the petitioners do not have specific information about registration of any case in the Sadgaon police station, but as police from the Sadgaon police station are stated to be seeking them, therefore they are apprehending arrest. And accordingly filed this petition. In the circumstances, call for a report from the Sadgaon police station as to whether any criminal case is registered against the two petitioners, namely so and so and so and so, Hijam Jesus and Pulendra Chakravarti. Full stop. Fixed.
Any FIR was not registered, that may be.
Yeah, no, well, whether any case has been registered or any FIR file, any complaint, FIR/complaint file at the said police station. That's fine. So, a week,
27?
27? 27?
Friday.
Friday? I don't know, it like, short time.
Very short.
You can take a chance, but it may not come also.
Tuesday, 26.
26?
Apply.
46.
But yesterday I mentioned for the appropriate bench, my lord, but since the bench is in the division bench, my lord,
Oh,
so matter has been referred to your lordship, my lord.
okay.
The office note is there, my lord.
Yes.
We don't give you, my lord.
This is for the co-accused.
Yes,
Co-accused. So it can come before me.
yes. So, my lord, this is the FIR is at page 9, my lord. This is a case which has been filed by my lord, the officer in charge, my lord, this Digonto Saloy, my lord, he's a police officer, my lord. He lodged a complaint against, my lord, the name accused and other 40-50 persons, my lord. The allegation, lord, people find it page 9, my lord. FIR, my lord.
Let us read the
Yes, my lord. With due respect, I would like to state that on 7/5/25 at around 4:30 PM, while I was on election duty, along with battalion staff at 150 number, Logao Gram Panchayat at Beltoli ME School, as the police sector officer. After the voting process ended, I requested people standing near the gate to move outside. At that moment, the accused person's name mentioned in the FIR, along with 40-50 other individuals, surrounded me. Using the pretext of my request, began physically assaulting me. The accused person assaulted me and the staff who were with me and obstructed me from discharging my duties. As such, I sustained serious injuries. They also torn my uniform and snatched my mobile phone after beating me. They did not stop there and they entered the polling center and tried to seize the ballot box. It is worth mentioning here that they also tried to threaten the presiding officer to rig the voting in favor of the particular candidate. When I tried to stop their nefarious attempt, the below named accused person along with the others as part of their secret conspiracy attacked me with the intention to kill me. So this is an FIR, my lord. So this is an FIR, my lord, that happened, my lord, inside the
ballot, voting center, my lord. And my lord, that we around 40-50 viewers are outside the my lord, center, my lord. So my lord, we are my lord, one of the my lord spectator to the incident, my lord. So my lord, my name has been there in the FIR, my lord, but my name has been mentioned as Babul Ali, my lord, the nickname, my lord. So my lord, if we go by the FIR, my lord, we are basically a standard, my lord. Bystander in the occasions, my lord. And my lord, the main accused persons, my lord, the Mujibur Rahman, he was granted bail by the Honorable Court. Lordship, may I kindly peruse this order, my lord. And my lord, if we go by the order, my lord, if Lordship sees, my lord,
Where is it?
my lord, I will say.
You want to submit it?
ये कोई नहीं, ठीक है सर, काउंसिल का भी है, लेकिन काउंसिल का भी है, तो सोना का क्या आगे करेंगे? My lord, may I kindly say, my lord, this FIR at paragraph number 3, my lord. The injury sustained by the informant, my lord.
Where?
My
Para
lord, may I
3 of,
kindly see, para 3, my lord.
of the bail petition.
No, of the order, my lord. The order by which this co-accused bail has been considered by the Honorable Court, my lord.
Yeah. It is submitted that para 3 is like that.
Yes, my lord. It is submitted that the medical report which has been submitted indicates that the victim has sustained simple injuries, which implies that there cannot be a case of 109. And my lord, may kindly see the order has been passed on 14th of August, my lord. So perhaps, my lord, this today is, my lord, 19, my lord. If city is therefore there before this court, my lord, before the PP office of the PP, my lord, then my lord, may I kindly peruse and my lord may consider the applications to the my lord. Otherwise, my lord, I am a daily wage labor, my lord.
The allegations per se are quite serious, right?
My lord,
It has all the elements of assault or even, trying to rig. So let us call for the case diary at this stage. I don't think interim would be justified. So anyway. G. Alam, learned counsel for the petitioners. 12,
what's my lord?
yeah, sure.
Yes, may I pay one thing, my lord, since my lord, 14 days, my lord, if CD might be at all there, my lord, at least my friend can inquire into it, my lord. CD is available, then I have to take instruction whether CD is available or not.
Oh, yeah, you can.
At two,
You
my lord,
can.
yeah,
If it is available, we need not waste time.
yes, my
I'll
lord, that's what
dispose
I'm
it.
telling. At two, my lord,
At
should we take?
Yeah, definitely. No
Yes.
problem.
Yes.
You find out if it's
Yes.
available, we
Otherwise,
take it up.
Lordship will pass on.
Yeah.
Plasma.
Alien 14.
Yeah. After some. Yeah.
Paying for adjournment for today, your lordship.
You don't want to do it today?
Yes, your lordship. My senior has some difficulties, your lordship. today.
Your good name, please?
Thank you so much. Return my.
No problem. So, Lord Counsel, seeks an adjournment for the day on the ground of the learned senior counsel being having some difficulties. This is, we have received scan copy. Scan
Yes, sir.
copy. Case at the stage of trial. Scan TCR has already been received. No problem. Then when do you want it?
Month of September or 8th September.
If it's not late for you, it's okay. I mean, first week of September?
Yes, your lordship.
First week of September. 5/9. Fix on 5/9.
We have received the case diary, but FSL report not received yet. The commercial quantity,
NDPS?
NDPS, 2,73,000 Yaba tablets.
Okay.
The lordship, the 48 notice is not served and the notice lordship, the 35 section says it's not compliant, lordship.
Diary has been received.
I received lordship today's 125.
He was arrested in 18-4. By this time, these rulings had come, I think. Isn't it? These rulings had come. Bihan Kumar
Yes,
and
yes,
these rulings had come. They should have followed. They have not followed.
No, Lord. 48 note.
So you just have to verify then.
47 is there,
40.
40, in a 48, a message was there, but notice was
Not served.
Detailed grounds of arrest.
accordingly informed his family members, guardian of accused person, namely Nur Islam. So we have to verify whether this notice was served or not, but it's a message is there.
As is there, but 47 notice,
47
they have
is there, yes.
grounds of arrest are
Grounds of arrest
there.
is
You know, they are specific to the person, it is there.
47 is there. Lord.
It is there.
48 not
Hmm.
served and the 35 Lord, if the not comply Lord.
35 may not, 35 may not be, it depends on the situation. If notice is not possible under 35, they have to give the reasons and satisfactory reasons that we have to see. So 47 notice prima facie appears to be okay, but 48 notice you kindly check
Lord,
from the records.
still another day I will come.
Another day or later today?
Topiam Lordship, at Topiam.
I have to communicate with them, verify it. So if he said another day, that will be better for me.
Okay. No problem. Mr. Ahmed
And
and Ahmed, learned counsel for the accused. DP Goswami, learned additional public prosecutor, submits that prima facie, there is no infirmity in the notice under section 47 DNSS. In the context of submissions by the petitioner counsel that notices have not been furnished properly, full stop. However, he seeks some time to verify from the records regarding the notice under 48, under section 48 BNSS. The prayer is allowed. Diary, you retain the diary? The case diary may be retained. When should I fix it?
29 or
29?
27 Lord.
You'll have to take instructions, you said?
instruction and if it is was served, then the copy
That-
of that.
that is
in the case there.
27 or 29, something like that. 28,
27.
28,
28.
28, 8.
Even the record of-
17.
Please, your lordship. 39 days lordship, driver and handyman of a vehicle lordship, 2 trucks were intercepted by the
Okay.
custom.
Okay,
Lordship recovered forensic item, lordship. That already been.
forensic. Hmm.
Already been seized by them, lordship, and we are behind about for last 39 days, lordship. Further custodial detention might not be regarded, lordship, and they have already taken 2 times for the case there.
Lordship, we are paying for short date, Lordship. Officer is on leave. We will produce case diary, Lordship, on Monday, Lordship.
Okay.
On
Okay, 2 days already gone, lordship. What remained, lordship, for investigation? Lordship? Already,
for short
Yeah.
date, Lordship.
Investigation is going on
Yes, Lordship.
or it's over? It's going on. Will it be possible for you to, can you try it on Friday? Friday.
Officer is going on Monday.
Oh, he's on leave. I see.
39 days, lordship, already seized, lordship. Forensic had only beginning of for that takes, lordship. Otherwise, lordship, there is.
But the quantity is also anyway quite huge. But anyway, the procedure has to be followed.
2 days
right?
already gone, lordship, for case there.
Kindly get it on the next working day. Monday is a holiday here,
Tuesday, Lordship.
Tuesday, right? M. Deka, learned counsel appearing for the DRI, submits that as the concerned officer looking after the case is on leave. Therefore, some time may be given to procure the case diary. The also heard to learned counsel for the, yes, I know, as Muni learned counsel for the, who however objects to any further time submitting that the accused is in custody since 13/7/2025. And the alleged contraband has already been seized. Nevertheless, the prayer of the Standing Council is allowed, fixed on 26.
Lordship, correction, Lordship, I'm appearing on behalf of SCK Lordship.
No issues, no problem. No problem. M. Dega appearing on behalf of CKL Standing Council. No worries.
Much obliged, sir.
Hello.
Much obliged.
Meeting.
We have not received a case diary in 18 Lordship.
Case diary has been received?
Not received.
Not received.
Not received.
He is in custody since 36.
UAPS, the Lordship. It is on the suspicion that my lord he is using is nothing else, my lord. Not that my lord something has been, my lord, it is suspicion that my lord he is using
Social media to.
social media for my lord, promoting
Ah, yeah.
activities, it's the suspicion of that.
Mhm.
And who is behind the bar for last, my lord? More than a month, my lord.
So we'll have to see the case diary. So just wait a little bit. When can you get?
Nalbari, Lord.
Nalbari. So that should not
Next
take
week.
much time.
Next week.
It is the case diary not yet received. The accused is in custody since 36/2025. Issue fresh requisition fix on
29/8/20.
29. Nalbari can be a little earlier, 27. Can you make it on 27?
27.
Try it. 27/8.
Much.
19.
Should this matter may kindly be taken up for some time, madam?
After some time.
20.
My lord, after some time, my lord.
This also.
As is in my file is.
Timing better action number 5.
This caution.
Please, your lordship, kindly 2 weeks may be granted to file additional affidavit, lordship. There is additional affidavit regarding to bring records on certain
things.
things.
Transit anticipatory bail. Priya Indoria. So that's why I said. So there's no interim order, right? Okay. J. Ghosh, learned counsel for the petitioner, submits that 2 weeks time may be given to enable them to file an additional affidavit to bring some new facts. The prayer is allowed. Of course, no question of diary here, right?
Not.
No, because this will be in another state. Karnataka.
Not.
Yes. Fixed on list after 2 weeks on. Let it be on 5/9, 2 days after 2 weeks. 5/9.
Oblige, lordship.
Number 21.
21 and 22 are the same. Lord.
Lordship, he is in custody for last 21 days, 28 days. And in this particular case, Lordship, may I submit? If there is no notice under section 35, section 41 are there, Lordship, there is no notice. And petitioner was suffering from various ailments. He is a patient of diabetes and heart patient. And he was in custody for 28 days. There is no prayer for any further judicial police custody.
Mhm.
And allegation is, Lordship, the false appointment letter issued to some person.
Right.
Lordship will find, main accused, Lordship will find the affair.
Fire at
Lordship will kindly page 17.
17.
That was filed by the Divisional Forest Officer, Srirang Division, Kajolgaon. It was filed on 21/7/2025.
Mhm.
Allegation is lordship. Appropriate and subject here stated in above, I am direct to hand over the appointment letters which were recovered by myself and me on 15 May last. In this regard, I would like to inform you that I was intimated about the matter over phone from the office of the Principal Chief Conservator of Forest Assam, head of the Forest Aryan Bhavan, Panjabari, Guwahati. Additional Principal Chief Conservator of Forest BTC Kokrajhar had also alerted me over the phone that some people might come to Sirang Division office to join with fake appointment letters. As informed, included 18 people appeared in the Divisional Forest Office, Sirang Division, and produced their appointment letters, which are found to be simply fake. Hence, the fake appointment letters are detained under the custody of Divisional Office, Sirang, for further inquiry. During preliminary, it came to light that one Shushanka Das of Nalbari mobile number was involved in mastermind of this racket and fake appointment letters distributions. So Shushanka was also arrested, and fake appointment letter also lodged their custody. There is nothing for investigation. Police may file a charge sheet against the accused, and he is suffering for 28 days in jail custody. Already, Lordship, he was referred to GMC. Lordship will kindly see the medical report. I have annexed page 40. Because it is not a conviction, he is in 28 days in jail custody. Page 40.
Page 14.
Page 40, the medical report.
Oh, sorry, 40.
Lordship, medical report
40.
during Lordship the custody. He was admitted in Nalbari Medical College Hospital. And thereafter he was referred to GMC for MRI and spine and further management. Page 640, Lordship.
I've seen
Stated, Lordship will find
I've seen.
29/7/2025 before after arrest.
Mhm.
He was initially admitted in Nalbari Medical College. Thereafter he was
Mhm.
referred to GMCH.
Mhm.
But he was not taken to GMCH at his own request that I will remain at Nalbari jail. And he was under treatment. So considering the period of detention as well as the notice, not charged. So Lordship, they were regarding unclean case. I have on last occasion given the Lordship Satyendra Singh unclean case, Satyendra Singh Nath case and the unclean case, where Supreme Court has categorically stated that when a person is not charged with notice, he is entitled for bail. And secondly,
No, not automatically. The grounds has to be
ground-
seen.
and considering the facts that he was in custody for 28 days, and there is no prayer for the police that he needed further investigation. And the documents has been already seized, the fact appointment letter has been seized, and that is already in the police custody. So, Lordship, there is no question of him keeping judicial custody for any period. And Supreme Court, Lordship, is aware that when a person is arrested and not served any notice, then he has a right to bail.
Notice under 35. 35. But the court, the IO has to justify, that has to justify why notice has not been served.
Lordship,
And that
when-
grounds are perused.
No, when the punishment is within 7 years, maximum punishment is 7 years, it is mandatory. And
It is-
Supreme Court has categorically
It
stated.
is mandatory, but the IO has to, if suppose somebody is arrested on the spot, then, it has to, they have to justify. And if
have to
notice is issued, then he cannot be
Lordship,
arrested
when
if he
pers-
appears.
When the person is a resident of Nalbari
You
district,
see,
and he is not a
you see the
person that he
provisions.
will flee from the place of occurrence.
You see the
And he is a
provision.
resident of Nalbari, permanent resident of Nalbari. And from his residence, he was arrested. Everything was charged in his house.
BNSS. Yeah, it's okay. Goswami.
Yes, okay, it's a organized crime, but several persons were
Yes.
involved in this, several persons were involved and some of them were arrested, Lordship. And
BNSS. Chamber.
issuing some fake appointment letter of, in the Department of Forest, Lordship.
Right.
That one of the main issues is Shashanko Das, he is a casual employee of the Forest Department, Lordship.
Yeah.
Also secretary of the Tuition, Lordship. And another, as far as this petitioner, Lordship,
Ms. Noor Hussain.
Noor Hussain, Lordship, he has also involved in this case with the Shashanko Das was instructed him to take some, his name is customer, Lordship, but not customer, who was the candidate, the candidates, Lordship. They issued fake appointment letters and taken money rupees around 50,000. Along with another person was there, also item number 23, Lokheswar Das.
Mhm.
He was also involved, and they are both there collected candidates and issuing the fake appointment letters demanding, taken money from them, Lordship.
Hmm.
And several witnesses were examined and 164 statement also they have of the candidate, Lordship. They have implicated the petitioner, Lordship.
Can you see the forwarding report? The grounds are there. There's some reflection in this order of the learned court below.
Page 26 Lordship.
Yes, yes, I found it's here also.
And investigation is almost complete. They have seized the document. IO has recorded statement of all witnesses.
No, investigation is complete. That is,
Almost complete.
no, that's for the prosecution to say. You know, that he knows. Maybe complete, that you can say.
What has been stated by the public prosecutor, we have to ascertain from the court have to ascertain.
The money was taken by the petitioner, Lordship. He was not refunded back and some other some persons were involved in this case who were yet to be arrested, Lordship.
Can I have a look?
But I have to flag mark this, Lordship.
May I read one paragraph of certain document until Lordship. Para 102, Lordship, already I handed over a copy of the order.
Yeah. Para 102.
Para 102.
What it says?
Investigating agencies and their officers are duty bound to comply with the mandate of section 41 and 41A of the code and direction issued by this court Ernest Kumar. Any deviation on their part has to be brought to the notice of the higher authorities and follow the appropriate order. Second, court will have to satisfy themselves on non-compliance with section 41A and any non-compliance would entitle the accused to grant bail.
Yes.
And that decision will subsequently followed by this honorable court and there is a direction to make inquiry against the police officer, departmental inquiry.
If notice is not given, then grounds has to be given. Why notice was
Ground
not
also
given?
not considered, this is a ground where the printed copy has been served. This is a printed copy. There is nothing in the record, in the forwarding letter, that he has inserted something from his own source, own writing. It's a printed form.
No, in compliance with the Vihan Kumar guidelines also nowadays, the detailed grounds of arrest are also in printed form.
Lordship, not on the format. They
It's
have
not
kept
a
record. He have to record.
printed form with fill up the blanks is different.
Lordship,
And something printed is different, right?
now it is printed.
So we should not confuse the two, you know, that looks like very mechanical, that fill up the blanks. But if it's if the narration is printed, it can be printed instead of being handwritten. Anyway, let me see. You can have a seat, please.
The petitioner is the person who printed the appointment letter in a place of Boromaro.
And during search, nothing has been recovered from the petitioner. It's an allegation. And petitioner will face the trial. If lordship, if it is established, which petitioner will convicted lordship.
Anyway, so, BA 26. The instant bail application has been filed under 483 BNSS, seeking regular bail for accused Noor Hussain, who was stated to have been arrested on 21/7/2025 in connection with Nalbari PS case number 223 of 2025 under section so and so. Good stuff. Heard S.K. Goswami, learned counsel for the petitioner. The case arose out of an Azahar dated 16/5/2025, lodged by learned DFO, Sirang Division, Kajalgaon, with the allegations that some people had come to the said office to join with fake appointment letters, and the said letters were detained, and during preliminary inquiry, it came to be known that one racket is behind these activities. Full stop. One person by the name Shushanko Das of Nalbari has been named in the Azahar. The learned counsel submits that in the meantime, there must have been significant progress in the investigation. All the documentary evidence, full stop. So documentary evidence have been seized. The petitioner has also been in custody since 21/7/2025. And full stop. It is submitted that he shall cooperate with remaining investigation, and in the event of being charge sheeted, shall face trial, but prays that he may be enlarged on bail at this stage. The learned counsel also raises a contention that notice under 35 BNSS has not been served upon him at the time of arrest. Full stop. The case diary has been received. Heard.
Petition suffering from various.
Oh yeah, that's sorry. After drawing attention of the court to the annexed medical papers, it is submitted that he is suffering from various medical ailments, which also necessitates grant of bail at this stage. I've heard DP Goswami, learned additional public prosecutor. The case diary has been received. It is submitted by the learned prosecution that investigation so far has revealed the involvement, has prima facie revealed involvement of racket regarding these fake appointment letters, whereby money is being taken from people and they have been cheated with false assurance of appointment in the department, forest department. Full stop. It is submitted that there are implicating materials not only against the named FIR, the FIR named accused, but also against the present accused Noor Hussain, and who stated to have printed some fake appointment letters in one press. I have also perused the relevant portions of the case diary. The statements of some alleged victims have also been recorded under 183 BNSS before learned JMFC. In one such statement, the alleged victim has implicated the accused persons, including the present accused, and stated about being cheated and induced through such fake appointment letters, and about payment of rupees 50,000. Also, regarding the aspect of notice, I perused the ground number 4, which is enumerated by the investigating officer. the time of arrest and I'm satisfied regarding the same, regarding the necessity of arrest. Regarding the health issues, I perused the medical documents. And I find that medical document dated 6/8/2025 indicating backache, hypertension, diabetes, etc. States that the patient has improved. Nevertheless, the allegations prima facie are of a very serious nature. And the investigation has also revealed implicating materials, lending support to the allegation in the Azahar about involvement of a racket in such manufacture of fake appointment letters. In a country where millions of youth are crying for employment in government and private sector, any truth in any activity of manipulation in public recruitment would be a very serious matter and has to be investigated properly and taken to the logical conclusion. Investigation is not yet completed. In the given facts and circumstances, I do not deem it prudent to grant bail to the accused at this stage, and accordingly, the bail petition stands rejected. However, the Learned Jail Authority shall provide necessary medical assistance to the accused for his medical issues, if any. Return back the case step.
Apply this.
23 arising out of same FIR also. 23. Yes, my lord. This Lokeshwar Das, my lord. This is also, materials are there also against this business also. But regarding manufacture of any document, my lord, there is. But he in fact.
They were arrested together, right?
Yes, my lord, 21.
Oh, Lokeshwar Das.
But his involvement in this offense, my lord.
Susanto, that is different.
Yes. He's Lokeshwar.
Okay, so
Lokeshwar.
have you checked with regard to him also?
Inspected in the adaptation of Nuru Singh
Hmm.
to do the offense, collected money and every candidate he has collected 50,000 rupees from the candidate of Lokeshwar Das. Sufficient material taken in lottery. We don't know. And Nuru Singh also said that yes, under the instruction of Lokeshwar Das, he is doing this.
উপরখিনি একে হবো উপরখিনি একে হবো this petition earlier bail petition আপনি না answer no oh I so you write this part only. The case diary has been received. The learned additional PP submits that investigation has revealed incriminating materials lending strong support to the basic allegations in the Azahar about involvement of a racket manufacturing fake appointment letters and cheating people by assuring them of such employment in forest department and taking money from them to the tune of about rupees 50,000 each. It is submitted that the investigation has also revealed implicating materials against the present accused Lokeshwar Das, who is stated to have worked in collusion with co-accused to conduct these activities of fake appointment letters. In the statement recorded before learned JMFC of one of the alleged victim also uh, implication is there against the present accused regarding alleged involvement in the these illegal activities. Accordingly, the given facts and circumstances, I do not deem it fit to grant bail to the accused at this stage, and the bail petition stands rejected and disposed of. Return back the case diary.
Right.
22.
Wait, please.
Yeah, Mr. Lam.
Doctor, consensual relationship law and allegation of rape.
Yes.
He was the driver.
No, he was not driver. From his place of business location.
Garage.
Scrap dealer.
Scrap dealer.
From in front of his shop that.
It was parked.
Yes, the vehicle was recovered. That another person, Babulali, to my information, that he was granted bail by the time. Or I did not get nothing. To my.
No,
During investigation and the CCTV footage, it was revealed that one Babulali and Lombu, they have stolen the vehicle. Tracks were along with the load articles of it. And this petitioner want to purchase the vehicle. He is a business, scrap business, who purchase the vehicles and sell it on by part lots. So he wanted to
purchase
the vehicle and when
which was stolen.
which was stolen.
Allegedly stolen.
Earlier also he has, as per his statement, yes, he purchased some vehicles and then later on stolen vehicle, later on he sell it by parts. He's kept and lordship from dispute arises that regarding some articles and some documentation of the vehicle lordship. That's why he didn't purchase the vehicle. So later on, he informed the owner of the vehicle, who was his name is Parag Das lordship, and he has given some advance money, and then later on he was returned back that money from the stolen regarding the stolen vehicle lordship.
If true is a good bad conduct, selling, purchasing stolen vehicles.
Stolen vehicle.
You can purchase vehicles and sell it for scrap. That's okay. But if
He
you
was
know it to be stolen,
Only thing is that he was
prima facie.
well aware of the fact that he has that the vehicle was stolen.
Here in this case, he refused to purchase and he had informed the owner. That's probably my understanding. He also agreed to that.
How much investigation has progressed?
Vehicle was recovered with the articles lordship, and one person yet to be arrested. 2 persons were there who stolen the vehicle. One is Lombu, other is Babulali. Babulali is arrested along with this petitioner also. And Lombu is yet to be arrested.
He's on the run. As per NDPS case number.
Considering the length of detention and the articles were recovered, and the fact which I have narrated in my story that he informed the owner lordship, that part corroborates with the city. Considering these aspects also at this time, he will face the trial if anything is there lordship.
483 bail application. And so for MD Ramzan Ali in custody since 27/7/25 in case of connection with Polasbari PS case number 186 of 25 under certain sections. The allegation in the Adahar was about theft of a vehicle bearing registration number AS01 CC 4692 loaded with dairy products worth about 9 lakhs. Full stop. Incident is alleged to have taken place on around the midnight of 23/7/2025. Third A. Ahmed, learned counsel for the petitioner. It is submitted that as the vehicle has already been recovered and it is the informant, it is the accused who informed the owner of the vehicle about the developments. On the other hand, the learned additional people, DP Goswami, on the basis of the received case diary, submits that though investigation is not yet completed, but truck and the materials contained therein have been recovered. It is also submitted that investigation has revealed some incriminating materials against the present accused as well. And he is prima facie stated to be involved in purchasing such stolen vehicles and selling them as scrap. Full stop. However, one is there, no? One is remains to be apprehended.
Yes.
However, considering the progress of investigation and the recovery of the stolen object, allegedly stolen object, perhaps the accused can be granted bail at this stage, subject to suitable conditions. Accordingly, 25,000 with one security, the satisfaction of the concerned learned court, and subject to the conditions that he will render full cooperation to remaining investigation. And he shall not abscond, he shall not hamper or tamper with evidence. Violation, it will be return back his diary, bail petition stands allowed and disposed of.
Chief Judicial Magistrate Kamrup.
Yeah, concerned learned. Kamrup Aminga or here?
Kamrup Abhinga.
No, concerned learned court, it's flexible. You can.
All right.
Activity they hearing BA 47. Where is the lordship, my lord? Here in the instant case of a notice was not served with the petitioner, my lord.
Supplementary bail here.
Yes, my lord. Another point I have found, my lord.
Just a minute, no? What is wrong? Oh, bail hearing. Just a minute. Okay, we had called for the scanties. You are appearing for the NCB?
One, so another point.
I'm having some, the microphone, I'm not hearing. Some audio is having some problem with the audio.
Another point, my lord.
You can submit. That's kindly cross check.
Oh, it is all of the seal, no?
You may also put it on.
It is all of the. Here, my lord, memorandum arrest, my lord, no witness is available, my lord. I was not caught red-handed, my lord. After main accused has been arrested, subsequently after 3 months after I was arrested, my lord. No witness is available. To that effect, my lord, I want to submit, my lord. Let's kindly go to the 41B, my lord.
41B of?
Code of Criminal Procedure,
Oh,
New Act 36, BNSS Act, my lord, 36B1, my lord.
36B1.
36B1, my lord. In this, my lord, every police officer, while making an arrest, shall bear an accurate, visible, clear of his name, which will be facilitate easy identification. Prepare a memorandum of arrest, which shall be attested by at least one witness.
Countersigned by the person.
My lord. Lordship, kindly look one thing, my lord. Both main important thing, my lord. DK Basu. Paragraph, my lord. I am 35 and 37, my lord. I am, my lord, highlighted those points, my lord. Read it, my lord. Lordship, kindly go to this file.
And you had taken a ground of this 47, 48 notice.
47, 48.
Let us come to that first, because that is more.
48 notice has not given, my lord.
That is more determinative.
Yes, my lord. 35, my lord.
Yeah.
Will the appropriate issue of the following cases arrested detained of these years? Two, 30th, the police of the carrying arrest shall be memo arrest at the time of arrest, such memo shall be
Yeah, yeah.
attesting one witness who may be either member of the family or arrest.
Now it is incorporated, now it is in the statute also.
Yes, my lord. And yes, my statute also, paragraph 37 categorically.
Suppose this is not followed, like
37.
47, 48 BNSS, we know.
Yes, my lord.
So that we know the consequences of that if it is not followed.
A para
So if a memo of arrest does not have a counter signature of a witness,
yes, my lord.
then will the arrest be invalid?
Yes, my lord. Para 37. Yes, my lord.
Para 37.
Yes, my lord. The requirement referred to the above flow from Article 21, 22, and of the Constitution of India need to be strictly followed. This would apply with the equal force of the government agency. Do reference has made.
Indirectly, it has been indicated.
Yes, my
Not
lord.
explicitly said so.
Yes, my lord.
Like Vihan Kumar and
Yes, my
Purkasta.
lord.
Not explicitly said so
Yes, my
that
lord.
this will render
Yes,
the
my lord.
arrest illegal,
Yes, my
but
lord.
indicated.
Yes,
This
my
is indicated.
And one thing is, last time she produced some document. I glimpses my lord that document. Lordship, kindly look whether the ground of arrest has been communicated to the family member, my lord. Okay, because it was not also not available in the record, but assuming but not admitting it is record whether ground of arrest has been communicated. Correctly.
I'll come to you. Don't worry.
Your Lordship, kindly look to that record, my lord.
It is there.
Lordship, TCR call for lordship, which is not received lordship.
Hmm?
TCR was called for
Yeah,
lordship.
okay, yes, yes.
It is
Last
not
bit.
their lordship.
We'll need the TCR.
Yes,
It is
lordship.
not come?
No lordship.
Not come. What is this then? These are judgments.
That is I given certificate settlement.
As per Vihan Kumar, I'm just refreshing. Vihan Kumar and Purkasta. Let's say Vihan Kumar, the second notice is also mandatory, right?
Mandatory.
43.
As per
50A and
Professor
48.
Singh. Yes, my lord.
Yeah, the second,
Yes,
the supplement.
last paragraph. my lord.
Supplement,
Yes, my lord.
supplement,
Yes,
the supplement.
it is mandatory.
So both are necessary and
Both are
without
necessary.
which to be.
And now I have
Anyway,
taken-
so that is the position.
Yes.
So, okay, so we'll need the scan TCR.
Yes.
Scan TCR will be necessary.
Short term. Because I have given certificate and apparently it was violated now. For this point.
47 notice was given? No.
47 notice was not given. So I have submitted last time.
Ah.
Subsequently, what happened? They took the
Oh,
signature.
I remember.
And that was not seen. my
Anyway,
lord. 48 notice is not available.
We'll, at the time of final adjudication, we'll see.
Yes, my
Rakhi,
lord.
Rakhi.
Nothing may give the short date, my lord, possible.
Heard NNB Chaudhary, Learned Counsel, who submits that apart from the grounds of non-compliance of section 47/48 BNSS, it is also contended now that the memorandum of arrest pertaining to the arrest of the accused does not bear the signature of any witness or that of the accused. And it is contended that this is in violation of the,
Accused signature is there, witness.
oh,
signature.
sorry, accused is not, witness is not there. It is violation of the law laid down by the Honorable Supreme Court in the landmark decision of D.K. Basu versus State of West Bengal, 1997, 1 SEC 416. The Learned Counsel in this regard draws attention of the court to para 35, subclause 2 and para 37.
And status to the DNA.
Full stop.
36 one.
Fine. No problem. Assisted by, kindly give your name.
So, KJ.
KD. I've heard M. Deka, Learned Counsel, appearing for the NCB on behalf of the Standing Counsel, SC Kyle. It is submitted by the Learned Counsel, Deka, that the scan TCR as called for has not yet been received. And issue fresh requisition for the scan TCR of NDPS case number 77 of 25. It will just repeat it, huh? Repeat the last para, last order.
Also, my fix a date, my latest from us.
You can suggest, but they are so overloaded, I think it will be, wise to give it a week.
Yes.
Week is necessary. So, will 29 be late for you?
Yes.
29, okay,
Can it be on 28th, Lordship?
28, okay, it's a hearing day, but we can fix it. It's a hearing day, it's better to fix it on motion day, but I'm fixing 28, 8.
Tell us, we will keep the certified copy. Remember on the various?
Yes.
Yes, ma'am.
If you want, what you can do,
No
keep the original,
necessary. No
and
necessary,
we'll keep a photocopy.
Tell us, you can give the certified copy. A photocopy is available with me. Awesome.
Very obliged.
Madam?
Ending item 20.
May please lordships. This is a 483 petition, my lord, regular bail application. In this case, my lord, can we have a look at page, my lord? Page 11, my lord. Page 11, the FIR, my lord.
Okay.
It is in, my lord, it will be better, my lord, to read out the, my lord, vernacular and page 13, my lord.
You can read the vernacular.
May I read, my lord?
Yeah.
In this case, the informant is Tahir Ali, that is the, my lord, father of the alleged victim girl, my lord.
Okay.
And the accused person is, my lord, number 1, Aryan Ali, and number 2, Mamoni Khatun, number 3, Nur Hussain. In this case, my lord, I am for accused number 2 and 3, my lord. I am not for accused number 1.
Okay. Yeah, I remember you told me
Yes.
that day.
মহাখন সম্মানপূর্বক বিনীত নিবেদন এই যে যোৱা 6/8/2024 6/8/2024 মাইলত তাৰিখে ৰাতিপুৱা অনুমান 8:30 মান বজাত মোৰ ছোৱালী ছয়ঞ্চ বয়স 14 বছৰক মোৰ ঘৰৰ পৰা উপৰোক্ত 1 নং আসামীজনে that is accused number 1 I am not for accused number 1 my lord 1 নং আসামীজনে ভালপোৱাৰ প্ৰলোভনেৰে ফচলাই পলুৱাই নি উপৰোক্ত 2 নং 2 আৰু 3 নং আসামীৰ হাতত গোৱাগাছা ৰেল ষ্টেচনত গটাই দিয়ে পিছত 2 আৰু 3 নং আসামীদ্বয়ে তাইক ৰেলত উঠাই অৰুণাচলত লৈ গৈ আসামীদ্বয়ে হোটেল এখনত বাচন বৰ্তন ধোৱা কামত
48.
48. Main bail technique. Main bail.
POCSO case, services awaited.
Services awaited.
48, not
48.
48.
Lordship, as per office note dated 19/8/25, service are awaited.
Awaited. So we'll have to wait for some more time.
Yes, Lord.
Service upon respond number 2 is awaited. Scan TCR is available. List after
It's up to September.
Date may continue.
fixed on 4/2, right? 3/9.
Okay. Same prayer.
Same prayer.
Lord, service is awaited.
Oh, same order.
1st of September.
Same order. 3rd of September.
Lordship.
Wait, to the lordship. As a 482 application, my lord. The petitioner, my lord, he was arrested on, my lord, 1/7/25, my lord. And thereafter, my lord, he was released, granted interim bail by the Sunball Court because of a cancer patient, my lord.
Yeah,
So, my lord, now thereafter, he was released on 9/8, my lord. So, my lord.
fine.
Yes, my lord. I will take your lordship to page 23 is an FIR, my lord. Suspected, my lord, brief, my lord, that has already been seized, my lord.
Okay.
My lord, and my lord is, I think the my lord, further custody may not be required because already he was in custody for 39 days, my lord.
There is
Case they received.
receipt.
He is the owner of the hotel, Lordship. Police recovered 5.570 kgs of
Suspected now.
and 850 grams also found inside the beef, which was
Cookpal.
Hmm.
And Lordship, he was the owner of the hotel, and the meat was sent to FSL for examination, Lordship. As per a statement of the, he had been selling beef in his hotel from a long period of time.
Lot of it. Anyway, let him.
Already,
No.
document is recorded now.
Cattle preservation, whatever that is provided, one should be within that.
Yes.
It should not be violated. So, first, para sebo. List of allegations. Full stop. Learned Counsel reiterates his prayer for bail. Reiterates his prayer for making the interim bail absolute, which was granted earlier, mainly on account of his illness and of being a cancer patient. DP Goswami, learned additional PP, submits on the basis of the case diary received that investigation is not yet completed. The suspected meat has been sent for chemical examination, and investigation has revealed that the present accused is the owner of the hotel and has been indulging in such activities violative of the Cattle Preservation Act for some time, for quite some time. Full stop. However, in the circumstances, also considering the progress of investigation, and also keeping in mind the medical condition of the accused, I do not deem it necessary to cancel the interim bail. And accordingly, the interim bail granted to the accused by the order dated 7/8/2025 is hereby made absolute, subject to the conditions that he'll render cooperation to the remaining investigation. Second, he shall not indulge in any illegal activities, including any activities violative of the Assam Cattle Preservation Act 2021. He shall not hamper or tamper with evidence. Violation. Return back case diary, bail petition stands allowed and disposed of.
81, Annabelle 32.
32.
May please, your lordship.
Yeah, Mr. Swami.
This is along with the item number 32. In
Yeah.
32, there is case there, I think, lordship.
Okay. Same FIR?
Same FIR,
Oh.
you know. And this application is, he was arrested on 27/6/2025, your lordship.
The diary has been received. So we'll take it up together, right? These two
Yes,
matters,
sir.
one after the other.
Yes.
So anyway, let us see the Azhar.
Lordship, page number 16, vernacular, your lordship.
Okay. You want to read the vernacular?
Yes, your lordship.
You can read.
May I please, your lordship. Page number 16.
Yes.
May I read, your lordship?
Yeah, go ahead.
বিনীত সন্মানপূৰ্বক নিবেদন এই যে আজি আনুমানিক প্ৰায় 1.5 বছৰ মানৰ পৰা তিনিচুকীয়া টাউন পাঞ্জাবী গলি শ্ৰীপৰিয়াৰ নিবাসী মৃত চৰণ সিং আৰু শ্ৰীমতী পৰমজিৎ কৌৰৰ পুত্ৰ শ্ৰী ওংকাৰ সিঙে মোৰ প্ৰায় 26 বছৰীয়া ভণ্টি শ্ৰীমতী মনপ্ৰীত কৌৰৰ বিভিন্ন ধৰণৰ প্ৰলোভন দেখুৱাই ভাল পাই আছিল। এইখিনি কথা আমি অনেক দিনৰ পিছতে জানিবলৈ পাইছিলোঁ। তেতিয়ালৈকে উক্ত ভাল পোৱা ভণ্টি আৰু ওংকাৰ সিং বহুত আগবাঢ়ি গৈছিল। আমি আমাৰ উক্ত ভণ্টিক সদায় আৰু প্ৰায় ঘণ্টা ধৰি ফোনত কথা পতা প্ৰত্যক্ষ কৰি আছিলোঁ। মই আৰু আমাৰ মা শ্ৰীমতী চৰণজিৎ কৌৰে কেইবাবাৰ বাধা প্ৰদান কৰোঁ, কিন্তু শ্ৰীমতী পৰমজিৎ কৌৰে মোৰ ভণ্টিক বেছিকৈ উচ্চতাই দিয়া বুলি আমি এক বিশেষ সূত্ৰে জানিবলৈ পাইছিলোঁ। অৰ্থাৎ আজি প্ৰায় এসপ্তাহ মানৰ পৰা আমাৰ ভণ্টিৰ স্বভাৱবোৰ আগৰ দৰে নাছিল। প্ৰায় অকলশৰীয়াকৈ থাকি ভাল পোৱা, কথাই প্ৰতি তৰ্ক কৰা ইত্যাদি। যোৱা ইংৰাজী 22/5/2025 তাৰিখে পুৱা প্ৰায় 7:30 মান বজাত মই আৰু আমাৰ দেউতা শ্ৰীযুত মহেন্দ্ৰ পাল সিং উক্ত ঘৰত নথকা অৱস্থাত আমাৰ ভণ্টি মনপ্ৰীত কৌৰ নিজৰ উৰণি দুপত্তাৰে ডিঙিত লগাই চিলিং ফেনত ওলমি আত্মহত্যা কৰে। এই সন্দৰ্ভত উক্ত পৰিয়াল শ্ৰীমতী পৰমজিৎ কৌৰ আৰু পুতেক শ্ৰী ওংকাৰ কৌৰৰ ওপৰত সন্দেহ হয়। আমি মনৰ দুখত এজাহাৰ দিয়াত পলম হয়। Only on the ground of suspicion, your lordship, the offence registered under section 108 of the PNS.
Abatement of
Abatement,
of suicide.
abatement,
Earlier 306.
earlier 306, your lordship, abatement of suicide. The abatement of suicide from the Ejahr itself, your lordship, there is not a single ingredient, your lordship. To attack this section, your lordship, section 45, definition of abatement. is
Yes.
there.
Instigation, aid,
Yes.
or conspiracy.
Yes, your lordship, from the Ejahr itself, it is clear that they have doubt.
Hmm.
Before this FIR, they have intimated the police station immediately on the day of incident. That is at page 21.
Page
Page-
two-
Page
21.
21, page 20, types copy. This is to inform you that I see Paranjit Singh, son of such and such, resident of Dibrugarh State, Assam. Today morning at around 8:30 a.m., my sister Manpreet Kaur committed suicide by hanging herself at our rented house, Ushal Nagar. After this information, they filed the FIR after 3 days, you know.
Hmm.
And then from this Ejahr itself, there is not a single ingredient to attack this section, you know.
Just a minute, huh? Let me. Hmm. They were arrested on.
Arrested on 27/6/2025 till today 54 days. Lord.
I see.
My lord, we have received the case diary, my lord, and as per the postmortem report, my lord, it's a case of suicide, my lord. Now,
Postmortem report.
Postmortem report.
I
my
see.
lord. It's a case of suicide, my lord. But as far as, my lord, the abatement part is concerned, my lord, there are materials because, my lord, this petitioner, my lord, Omkar Singh, my lord, he had a love affair with the victim, my lord. Then, my lord, he promised to marry her, my lord. And during that, my lord, during that period, my lord, they also indulged in physical relationship also, my lord. But what happened, my lord, before her death, my lord, the family members of the victim, they approached the, my lord, accused person to solemnize their marriage, my lord. And but, my lord, the family members, my lord, mother of the accused, my lord, that is petitioner number 2 in bail application number 32, my lord. They have, my lord, misbehaved, my lord.
There was difficulty in the relationship.
Yes,
actually.
that is why, my lord, she committed suicide. My lord. So that will be the these are the matter of trial, my lord.
Abatement is almost inevitably requires evidence.
Yes, my lord. So these are the, my lord, part of the, my lord, that has to be proved during the time of trial, my lord. Now, my lord, private basis, there is a material or not, that has to be looked into, my lord.
Can I have a look?
I have flagged my lord to game report and I have, my lord, statement of the.
483.
Yes, my lord, that may be proved.
Okay, 2664. 483 bail application. BNSS. For this petition is for Omkar Singh. and
Omkar.
The other person is not.
Other is the mother. That
My
is
lord, Omkar Singh also filed an anticipatory bail, my lord, but he was arrested, my lord.
That is why later on they have filed, my lord.
That became
They
infraction.
have later on filed, my lord.
Okay, became infraction.
Since he has already been arrested, no, that is why.
Okay. For Omkar Singh, stated to have been arrested on 27/6/2025 in connection with Moran PS case number 52 of 25 in the 108 BNS 2023. The Ejaha dated 24/5/2025 was lodged by Karanjit Singh, brother of the deceased. Full stop. The gist of the allegations is that his sister had a love affair with the present accused, and which was objected to by he and his mother, him and his mother. Semicolon, that subsequently they noticed some behavioral change in his sister, and eventually on 22/5/2025 in the morning he committed suicide by hanging. His home learned counsel for the accused submits that the accused is innocent and there is no element of abetment of suicide in the allegations, and submits that he has already been in custody for more than 50 days. The case diary has been received. Learned additional PP RJ Bora submits that as per PM report, it was a case of suicidal death. Though the investigation has progressed, but the same is not yet completed. Stop. It is submitted that there are materials against the present accused, though the aspect of abatement would perhaps be a matter of trial. Stuff. On the face of it, the unfortunate incident appears to have taken place in the backdrop of love affair and difficulty in the relationship on account of some family opposition. Nevertheless, the alleged offences are a matter of full investigation, as rightly submitted by the prosecution. However, I deem it fit to grant bail to the accused at this stage. Accordingly, he is allowed to go on bail of 25,000 once secured, subject to the condition that he shall not intimidate or harass the informant and his family. He shall not hamper or tamper with evidence. He shall cooperate with remaining investigation. Violation. Return back his diary. Bail petition stands disposed of. Any order, or this has become infractious, I think.
No, Lord.
No, my lord.
I
There are
cannot-
two accused persons, my lord.
In respect of her, his mother.
Oh, she is not arrested.
She is not.
So she was granted interim, my lord.
Interim bail.
Pursuant to that, she has appeared, my lord.
I see.
As statement record.
Other custodial detention may not be required, your lord.
AB so and so. Allegations to लिखी दियो पड़ेगा वो पर. The present petitioner is the mother of the main accused Omkar Singh, who was granted regular bail today by this court in another bail application. It is submitted that pursuant to grant of interim bail, the present petitioner on 19/6/2025, she has appeared before the IO and her statement has been recorded. In the given circumstances, it would be appropriate to make her interim bail absolute. Accordingly, the interim pre-arrest bail granted to petitioner so-and-so, Paramjit Kaur, by order dated 19/6/2025 is hereby made absolute, subject to the condition.
She may be directed to cooperate with the investigating officer till completion of the
She shall cooperate with the investigation and not hamper or tamper with it.
Lord. Oblige, Lord.
Bail petitions allowed and disposed of. Return back to.
Hearing 24. ABC.
AB.
May it please your lordship. May it please your lordship. I am on interim by order dated 11/4/2025, and I have also appeared before the IO 3 times. Just after the interim order on 17/4/2025. Thereafter, in the month of June, and recently on 7/8, and the IO has examined me.
Just give me a minute. I'll just peruse the narration in page 14. It first information,
Yes, sir.
right? Okay, you complete your submissions or should I go to madam?
Lordship.
Then you can come back. They can reply again. Case diary has come.
Yes, Your Lordship. Yeah, please, Your Lordship. This is an economic offences relating to the controller of defense accounts.
Yeah, I've seen.
Yes, of course, his name is not there, but he has,
Who's he? He is the present person.
he's the supplier.
His
He's the
name is,
supplier.
his
My
name
name is not mentioned in the
FIR, but
and also not in the forwarding report of the arrested.
Naveen Samaria.
Naveen Samaria.
Okay.
He's running his firm in the name of SM distributor. Your Lordship, in page number 6 of their petition,
It's of their petition.
last paragraph, they himself admitted the fact of recovery of incriminating document. It is on
Page 6, right?
page 6, last paragraph.
Last part. Can you read it? The aforesaid.
The aforesaid fact clearly shows that all the incriminating material had been seized, and as such, there is no chances of the petitioner tempering the evidence or hampering the investigation in the event of her enlargement on pre-arrest bail. So incriminating document has already been seized. One accounts seized.
Incriminating documents have been mentioned above, just above the paragraph, and note from the position of the present petitioner. These materials have been seized from the position of the arrested accused persons, and both the arrested accused persons have already been enlarged on bail by the learned CBI court by order dated 29/4/2025, as well as on 15/5/2025.
And your client, Naveen Samaria,
Yes.
what is the name of his concern? He's a businessman, right? What
Yes,
is the
he is a
name of his,
businessman.
what is the name of his firm? Can you help me with
SN
that?
distributor.
SN Distributor.
Yes. No, only SN distributor.
SN Distributor.
Yes.
But in his own statement, as per case diary, he is the owner of the MSSN Distributor and Durga Motor and Trading Company.
He may have multiple firms also.
No, lordship.
According to you, only this.
Only SN distributors.
No issues. Let's not get stuck with that.
He has a conversation with Sylvia Vadani, controller of, she is auditor in the Controller of Defense Account Guwahati. So he himself, during the course of interrogation, in the statement, he said, the question is, how do you get the mobile number of Srimati Sylvia Vadani, Senior Auditor, Controller of Defense Account? He said, Sylvia Vadani, Auditor, Controller of Defense Account Guwahati, used to inform me about the bills and ask me for undue advantage in respect of processing the bill. Since she was continuously pressurizing me over phone to give undue advantage of rupees 2,72,000
This is not
in
true,
lieu of
lordship.
processing the bill, so I told my sister-in-law Sabita Chamaria to deliver undue advantage of rupees so and so to Srimati Sylvia Vadani through one Vikas Sarkar. This is the statement which is in the case diary.
No, lordship. This statement is not true, lordship.
This is, you denied the statement.
Yes, lordship.
It is in the case diary.
His own statement.
His own statement.
Might not be admissible, but
And there is
pursuant to examination.
disclosed that he used to pay the amount to the Sylvia Vadani, who is processing the bills. And she is dealing with the James, and from the James, she used to collect the addresses of the suppliers, and thereby she used to contact. There is a telephone conversation in this case diary in between Sylvia Vadani and Naveen Chamaria.
The conversation, lordship, the conversation may be seen because I have never offered any bribe amount to the arrest Sylvia Badani. I have just called her to inquire the status of my bills, not for sending any bribe amount, lordship. And moreover, the name accused Sabita Chamaria has already been granted pre-arrest bail by this honorable court. Firstly, the interim protection on 9/4. Later on, it was made absolute by order dated 10/6/2025, lordship.
Disparity cannot be granted in the criminal case that is based on the CD. He has been granted bail or anticipatory bail. Here in the CD, it is already there. नवीन जी से बात हुई थी. हाँ, बात हो रहा है. मेरे को एक टाइम बताए ना. अभी पाकर लीजिए 20 मिनट तक लगेगा. It is there in their conversation. If your lordship would like to.
As per the allegations, the allegations are about abatement as far as he is concerned, right?
He is the supplier. He used.
No, that will be abatement since he is not a public servant.
He is not a public servant.
Public abatement of bribery.
Abatement of bribery, but now a person in 2018, even the person who is the giver of.
Yeah, that's why I said, man. There's no specific offense as far as I know about, the offense of giving a bribe. But the bribe givers are prosecuted under abatement, right? Abatement of bribery.
Abatement is now a substantive offense.
Offense, yes.
Treated separately.
Yes, that's true. That's true.
Treated
That is how
separately.
they
That it
come
is
in.
not
No, sometimes
should be read with
yes.
section 7(9).
So we do not know the facts, sometimes the businessmen have their vulnerabilities. This is understandable. But if some person in business is actively, colluding with officials, in bribery and to manipulate the system, then definitely, they're guilty of offenses. But now we don't know. So kindly complete your submission and then you just point out to me which areas I should see. Telephone
From the
conversation, if
detail
you
it
want to
has
read,
been-
you can read, no problem.
From this call detail, it is in the.
You can read,
Hindi, though it is a.
doesn't matter, you can read in Hindi. That will be
It is
natural,
the-
actual conversation.
Actual conversation I am coming to. With the Sylvia Badani. Sylvia Badani is there, who is, from whom this Naveen Chamaria is under contact with regard to the processing of the bill.
Right.
And Savita Chamaria is a sister-in-law of Naveen Chamaria. They are running the business.
Mhm.
But her business was separate. Her firm was separate.
Okay, fine. She has been granted bail.
Yes, Lord.
Okay.
Here it
The
is-
main named accused is Minmoy Ghosh.
Minmay Ghosh.
He was trapped.
Trap?
Red-handed, yes,
Trap case?
red-handed trap, red-handed.
Anyways,
Now it is in the verge of filing of the charge sheet. So, because FIR is of April. So as
Third
of
of
now,
April.
the stage is filing of the charge sheet. So at this stage, this anticipatory bail is not maintainable.
But the charge sheet has not been submitted yet, Lord.
no, it will be maintainable, madam, but I think, my humble opinion. But, the merit will be different matter, of course. So kindly, let's proceed. You can submit the gist also after reading.
My whole concern is that it is economic offenses, and if he is allowed to be protected, then it's very difficult to unfold that.
Lordship, it's, the FIR has been rolled almost 5 months back, and all the accused persons have been enlarged on bail by the Learned Court below. And
They were arrested.
um,
Regular bail or anticipatory bail?
regular bail. Both the accused have been Minmay
So
Ghosh and
red-handed trap is there, red-handed trap is there.
Vikas
So
Sarkar
regular bail is there.
Vikas Sarkar and Minmay Ghosh. And in the order itself, it has been explicitly mentioned by the learned CBI court that investigation has been proceeded to large extent. There nothing remains for investigation.
Madam has also said that it is their investigation, but, his statement has been recorded. This,
Yes, Lord.
This is, he himself said that Sylvia Vadani used to ask for money.
No, Lordship,
His
never,
statement is there.
no, never said. Because on the last occasion, I was also present along with the petitioner
I'm going
before
to
the
the
IO
CD,
Lordship.
if I'm going to the CD.
I am continuing to cooperate with the investigating officer, and I have appeared on 7th also.
documents have been seized mostly. Anyway, can I have a look after you finish? EC economy. ECF, Prevention of Corruption.
Missing one judgment of this court.
Decision. Conversation is. You can start. You can have a seat. Take 5 minutes. B. Mr. Agarwal, right?
Yes.
G. Agarwal for the petitioner. Seeking anticipatory bail. And M. Kumari, learned standing counsel. Retainer counsel, you prefer to be
Retainer counsel.
Retainer counsel? CBI. तो आपने ये लिख लो 11/4/2025 और सेकंड पैरा. Agarwal, learned counsel for the petitioner, submits that the present petitioner is not named in the FIR lodged by the CBI, and pursuant to grant of interim protection by order dated 11/4/2025, he has appeared before the investigating officer of CBI, and his statement has also been recorded. It is submitted that the petitioner shall continue his cooperation in the investigation, and therefore his interim bail may be made absolute. The gist of the allegation in the Azahar, in the FIR, leading to the registration of the case is that one Mrinmoy Ghosh, senior auditor in the Office of Controller of Defense Accounts, Narangi, Guwahati, regularly used to indulge in corrupt practices by demanding and accepting bribes from private vendors and contractors for passing their bills. In this regard, the names of some persons and their concerns have been mentioned. Full stop. It is also alleged that the named prime accused is habitually demanding his undue advantages. Stop. Which constitute offenses under the Prevention of Corruption Act 1988, as amended in 2018. 3 persons have been named in the Azahar, in the FIR, including Mrinmoy Ghosh, namely Mrinmoy Ghosh, number 2, Sabita Samaria, and Vikas Sarkar. Stop. And also unknown persons. They were alleged to have entered into conspiracy for undue gain, constituting offenses under the Act. I've also heard M. Kumar's standing retainer counsel, CBA. The case diary has been received and placed before this court. On the basis of the case diary, the learned retainer counsel submits that investigation has progressed and the same is proceeding towards submission of charge sheet. It is submitted that the statement of the accused reveals about his own involvement in these activities. Needless to say that the said statement would not be admissible for any attribution of guilt. I've also perused the interrogation report of the present petitioner in question answer format. The learned retainer counsel CBI has drawn my attention to transcripts of telephone conversations. Which prima facie are implicating in nature, lending support to the involvement of the various persons named in the Azahar as well as others, including the present petitioner, with regard to the allegations about being involved in facilitating the main accused in accepting bribes for transactions undertaken with the Office of the Controller of Defense Accounts. Considering the nature of the materials that I have noticed in the case diary, I'm of the considered opinion that though investigation has progressed, the CBI should be given full latitude to complete the remaining investigation and go to the root of the alleged allegations. In such view of the matter, I do not find sufficient merit in this anticipatory bail, which accordingly stands rejected at this stage. Full stop. The interim bail accordingly, therefore stands vacated. Return back the case diary.
Lordship, I want to just give you attention that the conversation between Sylvia Badani and the petitioner may be heard in the pen drive because the petitioner has already been cooperated with the investigation and investigation has
Followed the direction of the court, So, but these are very, serious matters, prima facie.
Lordship, I have already cooperated, Lordship, and my
Very serious matters, corruption has ruined our system. We have to be very, very strict.
Lordship, I have
People don't have stake. 99% people are victims of corruption.
Lordship, I have never given any.
I'm not saying it is an allegation, but why the court should not put any restrictions on the investigation? Let them investigate. Let them investigate.
It will come out.
Lordship, some time may be given so that I can.
No, don't worry. It's
Deviate.
finalized. Don't worry. Don't take any tension. You have submitted. The court has passed an order. It's not in your hands. Okay, after lunch?
Lordship.
Yeah.
Basically, the FIR, the vernacular of the FIR is in page 16 to 17.
Start, my lord.
Yeah.
I beg to submit, my lord, we have received that case diary, my lord. The
Hmm.
petitioner there on interim, my lord.
Mhm.
But its case diary is not appeared, my lord. Whether they appeared before the IO, their statement recorded or not, my lord, this is not clear.
Not clear?
So I pray, my lord, let the matter come after 2 weeks, my lord. In the meantime, we'll call for the up-to-date case diary.
That is your submission.
Yes, because, my lord, whether they have appeared before the IO or
Okay.
not,
Ah,
this is not clear.
Okay, so you complete it, whatever you want to say.
Your Lordship, the FIR is in vernacular page 16 to 17, Your Lordship.
As per your instruction, have they appeared?
Yes, Your Lordship.
They have
he has
appeared? They have
He has
appeared?
appeared twice before the IO.
Oh,
In interim period, is it?
Interim date is 28/4/2025.
It
Page
is up to, my lord, 10/4, my lord, that is why.
oh. Not very updated.
The FIR is in page 16, basically. May I read, Your Lordship?
Yeah.
সন্মানপূৰ্বক বিনীত নিবেদন এই যে যোৱা ইংৰাজীৰ 7/11/2024 তাৰিখে উপৰোক্ত পদকীয়া দুয়ো মোৰ ঘৰত স্বৰ্গীয় মানিক চন্দ্ৰ চৌধুৰীৰ পিতা স্বৰ্গীয় গন্ধৰাম চৌধুৰীৰ নামত উত্তৰাধিকাৰীৰ প্ৰমাণ পত্ৰ বিচাৰি আহে। উক্ত সময়ত মই বহুত ব্যস্ততাৰ মাজত থকাত তেওঁলোকে নিজে প্ৰমাণ পত্ৰ লিখিব বিচাৰাত মই লিখিব দিওঁ। প্ৰমাণ পত্ৰ নং 488 খন মই নিজে পঢ়ি বুজি চাই চিল চহী কৰি দিওঁ যদিও পদকীয়া দুয়ো পিছত উত্তৰাধিকাৰীৰ নামবোৰৰ বিপৰীতে ওৰফে শব্দ ব্যৱহাৰ কৰি আন 3 জন ব্যক্তিৰ নাম লিখি দিয়ে। পদকীয়া দুয়োৰ বিৰুদ্ধে গাঁওবুঢ়াৰ প্ৰমাণ পত্ৰ জালিয়াতি কৰাৰ অভিযোগ আছে। This is basically the case. Your Lordship, actually the deceased whose next of kin has been applied, basically he is the late grandfather of the present two petitioner. The present two petitioners are our cousins, basically, Your Lordship. Their fathers were brothers, siblings, and it is the kin certificate of their grandfather, Your Lordship, because their father also expired.
Mhm.
So what happened when they went to the place of the village panchayat head to obtain the certificate, he, by doing every verification, gave seal sign on that particular certificate. And after that, based on that particular certificate, when their names were mutated in the land records, and that particular land was taken by the government, Your Lordship, due to the construction of the Shwalkuchi and Panjavari flyover, Your Lordship. So when that land was acquired by the government, they got hefty amount of money from the government under the Compensation Act, Your Lordship. So the village panchayat, along with his son, tried to extort money from the present petitioners. And when they denied to give them the share of that particular amount, he threatened, the village panchayat, along with his son, threatened the petitioners to file a false first information report. And thereafter, after 4 months of the alleged incident, they lodged this present FIR.
The incident is,
Incident is of
24.
11/2024, and the FIR was lodged on 23/2025 after 4 months. Your
Anyway,
Lordship.
you were granted interim, so
Yes.
as you have submitted, let us.
Yes, Your
yeah.
Lordship.
Your Ms. P. Deka,
J. Das, Your Lordship.
J. Das, learned counsel for the petitioner, has taken the court through the allegations in the Aadhaar and pointed out that apart from the allegations being false, the Aadhaar has also been lodged several months after the date of the alleged incident. She has also indicated that false case has been lodged due to family dispute with regard to share of property, share of
Family
compensation,
Yes.
compensation, dispute between family members with regard to compensation, share in compensation.
Family members, Your Lordship. He is the village head.
Okay. let's leave that part of, not necessary. RJ Borua learned additional PP, however, submits that though the case diary has been received, but it is not updated. And the statement of the petitioners pursuant to grant of interim is also not available. And due to is also not available. However, in this regard, the learned counsel for the petitioner submits that they have already appeared before the IO twice and their statements have been recorded. So call for the the present the case diary may be sent back and the up-to-date CD may be requisitioned. The order of interim bail shall continue till the next date of listing. Okay, let it be like that.
8th of September.
8th of September, 8/9/2025.
Okay.
Yeah, okay, this one. Should we take up this matter, this voluminous case diary?
Yes, my lord.
Or after taking out the other matters?
No, my lord, Lordship may take it, my lord.
Okay.
No, my lord, only my one submission, my lord.
Uh.
I beg to place one decision of the Honorable Appellate Court, my lord.
Mhm.
So, my lord, let
Darshan.
the matter, I'll also go to, but I have not been able to go through completely, totally, my lord.
No,
So, let the matter come up day after tomorrow, my lord, so that we can.
busy also.
14.
Lordship,
Last another matter, my lord, in connection with the same police station, my lord, because they started that case, my lord. That is fixed tomorrow, my lord.
Mhm. I
This is
see.
why, my lord, only, my lord, I'm by going through these judgments, my lord. Huh? 14 now. Day after tomorrow.
Started case, Lordship, LCR is called for, my lord.
Hmm.
LCR is there, Lordship, on the ground of arrest, my lord. That is on record, Lordship. I have also filed additional.
Let it be, you want day after tomorrow?
Day after tomorrow, my lord, Lordship may kindly pay, my lord, paragraph 20 of the judgment, my lord. Paragraph 20 onwards, my lord. Lordship may kindly come to paragraph 21.7, my lord. Jan Kumar and Probin Purkasta, my lord, these are all, my lord, discussed, my lord, in this judgment.
This is a very recent judgment,
Recent judgment, my lord, dated 14th of this month, my lord.
14th of this month.
This month, my lord.
I see. 21.
20.1.7. Yes, sir. State of Karnataka versus Torso.
Yeah. In that case, this will require a deeper deliberation. We have to go into this. Has the position of law laid down now so far by Purkasto and Vihan Kumar been slightly modified by this interpretation?
Yes, ma'am.
Two judge bench.
Yes.
Quorum is 2. So we have to
I'll
see.
also go through my.
Delay is delay is slightly
delay part
is one
part
matter
the delay part,
and the
my lord.
contents is another matter. If
Yes.
the contents are there, but the slight delay, maybe that may be a curable defect.
Yes.
So first we have to see whether it is available at all.
So, my
And secondly, if available, what is the content?
content.
Then the question of delay,
Yes.
right? So I would have preferred it to be on Tuesday actually, because Friday,
Let it be on
since,
Tuesday, my lord.
I'll leave for 2
Because,
weeks.
my lord, today I have, my lord, I have
Uh-huh.
got the copy, my lord, so I have to go through also, my lord.
I may have some constraints on Friday because I'm going for 2 weeks. So Learned Council agrees we can fix it on 26th. Okay.
Lordship.
I don't remember. The Learned additional PP RJ Bora submits that that he's relying on one decision one very recent decision of the Honorable Supreme Court, being, it will be State of Karnataka versus Darshan, 2025, SCC Online, SC 1702. And seeks some time to prepare his submissions in the context of the position of law laid down in that judgment, in that very recent judgment. The learned counsel for the petitioner fairly agrees to the same, fixed on 26/8/2024 bail year. We'll go through it, do the hearing. Necessary, I will check it later. Okay.
Item number
Good.
26.
Twenty-six.
Item number 26.
Actually, earlier two dates also none had appeared. Scan copies are received, I believe. Oxo matter. None appears today also on call. Scan TCR has already been received. It's an anticipatory bill. Fix on 29.
29/8, my lord.
29/8.
Eight.
8.
27.
Made to the lordship.
Yes.
27 and 30, my lord, may be taken up
Taken up together.
27 and 30. Here, my lord, both of petitioners are.
Same FIR. no?
Same FIR, my lord, interim, my lord. In fact, they are brother-in-laws, my lord. Both are on interim, my lord. The SBI statement is recorded on FIR at page 12. The gist of the FIR is that one Nazrul, my lord, one Nazrul Islam, the brother of the petitioner in item number 27 and brother-in-law of the petitioner in item number 30. He submitted a fake higher secondary certificate in the last, my lord, Panchayat elections, my lord. He was contesting that, my lord. Eventually, he was arrested. Subsequently released on bail, my lord. Now, there is no allegation against this person, my lord, the petitioner before your lordship, as well as petitioner in item number 30. They were granted interim protection. They appeared. Their statement
I see.
has been recorded, my lord. So, kindly peruse, my lord. They have pursuant to 30/30 notice, they have appeared, my lord. The last two lines, my lord. First page, my lord. First page, very first page. Last two lines.
Oh, notice was issued and they have appeared.
Yes.
It's okay. Then make it
So
absolute.
they have purported, my lord.
Make it absolute.
Lordship may note, my lord, the order is, my lord. Whatever the IO has mentioned, my lord.
Yeah. I will mention. Otherwise, there's some progress in the investigation.
Investigation
Seems-
sufficiently progress, my lord. Mainly because they arrested, my lord.
It was order dated 5/6/2025. Para 1, 2, 3 will be same. Thereafter. It is submitted by the learned counsel for the petitioner that pursuant to grant of interim bail, they have appeared before the investigating officer, rendered their cooperation to the investigation, and their statements have also been recorded. The case diary has been received. And third learned additional PP, RJ Boru. I find from the case diary that IO has not submitted any bail objection, as the applicant is stated to have already been served notice under 35, section 35 within bracket 3 BNSS, and arrest was not found necessary. In any case, investigation has also progressed. In considering the cooperation rendered by the petitioner, the interim bail granted to the petitioner by order dated 5/6/2025 is hereby made absolute, subject to the conditions that they shall cooperate with the remaining investigation and shall not hamper or tamper with evidence. Return back the case diary. This is similar?
Same, Malad, but the interim was granted on 6/6/6/25.
Otherwise same.
Same, Malad. Your interim was granted on 6/6/25.
It will AB 1269, 1269. Otherwise same, but the date of interim is 6/6, next day, 6/6/2020. Disposed of,
And
allowed and disposed of, return.
Right.
people. Yes.
May it please the Lordship. In this case, Lordship, the petitioners have been already.
I am appearing for informant.
Yeah.
Or in informant, I filed my objection also.
Okay.
May I
Yeah.
please, Lordship? Lordship, in this instant case, Lordship, while interim order dated 6/6/25, we were provided interim protection, Lordship. We appeared before the investigating officer and we have cooperated with the investigation, Lordship. Now, Lordship, may come to the FIR at page 23, Lordship. If I may, Lordship. Page 23, Lordship, annexure A1. If I may, Your Lordship, most respectfully, I would like to inform that today at around 3:30 PM, Mr. Raj Kishore Singh, that is the petitioner number 1, Lordship, Mr. Ritesh Ranjan Singh, petitioner number 2, and Sujata Singh, wife of Mr. R.K. Singh, and Muskan Singh, wife of Mr. Ritesh Ranjan Singh, sent a group of persons to the counter of BN Singh petrol pump, who started fighting and hitting us very badly with an intention of murder. They were telling us to leave BN Singh petrol pump and hand it over to Mr. Ritesh Singh and his family. Otherwise, they will murder us. A video footage is also available with us of the fight scene. So this was the FIR, Lordship. Now, Lordship, to come to the basic facts of the case, Lordship, may kindly come to page number 24, Lordship. Now, this is the general power of attorney, Lordship. This is the lease deed, Lordship, whereby the informant, that is Mr. Raj Singh, and who is the proprietor of the petrol pump, had given the said petrol pump to us on lease, which expired in the year 2024, Lordship. Even then, through a verbal understanding, Lordship, we were continuing with the running of operating the said petrol pump. Now, thereafter, Lordship, may kindly peruse annexure D, Lordship. That is page 30, Lordship. Page 30, Lordship. This is, Lordship, an extension of the lease deed, Lordship, dated 1/4/21. Because prior to this, Lordship, they had entered into an agreement, which even my learned friends as the representing the informant had filed in their affidavit, Lordship, whereby it was agreed upon that they will extend the lease. And thereupon, Lordship, this lease deed was executed. This extension letter was sent to us, stating that it is for your kind information that the tenure of lease dated 1/4/21 has been extended for another period of 3 years, and the aforesaid lease is valid up to 1/4/27. So, Lordship, and to reach into this agreement, Lordship, the petitioners even sold their own properties, which was given because there were some anomalies with regard to some financial issues, which was cleared up, Lordship, and thereafter they were operating. Now, on that fateful day, Lordship, what has happened? But the factual matrix was the wife, that is Sujata Singh, she was called to the petrol pump by the informants. Now, the informants had in a very preconceived manner, had planned to oust the petitioners hearing from operating the petrol pump.
Despite the lease
deed and despite the extension, Lordship. Now, what had happened, and after collecting around 3 crore rupees from them also, from the petitioners. Now, in this case, what happened when she went to the petrol pump, she was confronted by all the informants, and when a hue and cry was being raised, some of the local residents came, Lordship. And when such local residents came, there was some
scuffle.
no, Lordship, some verbal slangs used to the local community, which was apparent even in the news, Lordship. And then some local groups got involved and some altercation happened. We were nowhere connected in it. Even Lordship, if your Lordship sees from the FIR itself, it states that we had sent. So basically, Lordship, they use the concept of strike when the iron is hot. That is a civil dispute. And moreover, Lordship, before that, Lordship, your Lordship may kindly come to Annexure E, Lordship, page 31.
Annexure E, page 31.
31, Lordship. Lordship, already on 13th May, we had filed a title suit with regard to the dispute which was happening with us, which is also pending adjudication at this moment also, Lordship, before the Civil Judge Senior Division at Dibrugarh. That was filed on 13th, Lordship, and the FIR thereafter was lodged, and even there was a interim order protecting us at that point, not protecting us, we paid for interim order, Lordship. So all this was going on. Basically, it was a civil cause of action which had accrued. Now, since such a dispute altercation between some local passerbys happened, they, with a very malafide intent to portray it as just to arm twist us and oust us from this application, Lordship, or from operating the pump, had filed this instant case, Lordship. And Lordship, moreover, in this case, other accused persons were also implicated and even arrested. And to that effect, since they were cooperating with the investigation, this Honorable Court was pleased to even release them and make their bail absolute, Lordship. I'm just providing an order of the same, Lordship. It will be Lordship, my humble prayer here is that, Lordship, I am cooperating with the investigation, Lordship, time and again. Now, after this, Lordship, the informant might come and say that there are other cases also. Now, even though there is no subject matter of this bail, Lordship, what I am on to before this Honorable Court is that even in those cases, even for the sake of argument, we take those cases, there was that extension date, they are now putting an accusation that it is forged by us. But it was us who had brought it in the public purview. We filed the title suit before and we brought the document.
I see.
That is our humble prayer, Lordship, that the bail may be made absolute, Lordship.
Just a minute.
My lord, we have received the case diary, my lord. Pursuant to the interim direction, my lord, they have appeared, my lord. They have that statement also recorded, my lord. And along with the case diary, my lord, the medical reports is also annexed, my lord. So medical report is simple, caused by blunt weapon, my lord. So my lord, 100 and my lord, 1172, my lord, may not come, my lord.
No, it won't come.
And my lord, this is a dispute, my lord, with regard to a petrol pump in
Petrol pump. The backdrop is a civil dispute, no doubt.
Person, my lord.
But it can have elements of criminal law that we know.
These accused person,
But that we cannot say now, actually, right?
Investigation is going on, my lord. These accused person, they are father and son, my lord. They, my lord, allegation is that, my lord, they along with some other person, my lord, they went to, my lord, to capture the petrol pump, my lord. By force, my lord. Then, my lord, the incident took place, my lord.
Took place.
That is my submission, my lord. Investigation is pending, my lord.
Investigation is going on.
Yeah.
So the facts and document which my learned friend had projected, my lord, it looks like very simple. This is not a case like that, my lord. This is a case why on that day, in fact, father and son, they are network law of present era, your lord. How your lord may kindly come to my objection. And your lordship may directly pass to page 102. Objection filed by informant, your lordship.
Your affidavit?
My affidavit, my lord. Affidavit in objection. It starts from 73. Running page, my lord.
You want me to come to 102? 102?
102. My lord.
This is another Ejahat?
My lord, given by us, my lord. Subsequently. But before that, there is an agreement. I will request my learned friend, let me conclude, my lord, then my learned friend.
Okay, no problem. You can.
Paragraph 3, your lordship may kindly see, the informant further states that during the tenure of the said lease agreement, Sri Ritesh Singh, one of the petitioners, in connivance with his father, Raj Kishore Singh, Sri Subhas Singh, an official of ICICI Bank Dulia Jan, in after referred to it so caused heavy outstanding dues payable to ICICI Bank Dulia Jan under account number so and so, type so and so, amounting to rupees 2,81 lakhs 46,781 and 89 paisa. When the dealer of the proprietor of the pump came to know that they are doing misappropriation of fund. They have taken loan in against my name. Then, my lord, one agreement was entered because at that time he was, who is the owner or who is the dealer, my lord? I am the dealer. It is up to me to choose X or Y. But when I came to know that father and son, they are doing mischief, then, my lord, one agreement was entered that your lordship will find at page, starts from 86 and relevant page 91. And para number 3, and whereas your lordship has got it. This is an agreement entered into
96?
page 91.
Okay. Memo of understanding. Mhm.
And para 3, your lordship. And whereas in the process of running and conducting the petrol pump, the second party caused heavy outstanding due payable to ICICI Bank, Duliajan, account number so and so, standing in the name of BNC. At present, there is an outstanding of rupees 2,81,46,700 and so on. Next, my lord. The second party, father of today's second party, admits the fact that the second party, party number 3 have diverted, misused the funds. This is admitted position, my lord. Only to cover, my lord, this aspect, what they have done, they sent some sponsored person in my petrol pump. And in that day, my lord, the target was to, my lord, maybe, my lord, I may be, injury was not so much, but in that day, there may be intention of that. Who is the mastermind, my lord, who has written this script? It is not before your lordship. They have sent some gundas and some local persons, and they tried to capture that petrol pump on that day. When we see entire story, your lordship will find that only because he has been sacked from that petrol pump. To counter that, my lord, everything has been done. Because why he was sacked? Because he has misappropriated around 281 crore rupees, your lordship. He has taken loan and loan is standing in my name. I have to pay.
The extension is
Extension forgery, my lord. Against that also FIR has been given. That your lordship will find at page 82. It was manufactured document. They have manufactured it. Page 82, my lord. 2 FIRs were given. So, my lord, entire thing has to be looked at, my lord. Otherwise, simply reading one FIR will not fulfill the purpose, my lord.
which is that is
page 82, my lord.
82. Okay. 82.
The informant states that Mr. Raj Singh, representing his second paragraph, my lord, his proprietorship firm GN Singh has extended into a lease agreement 1st April 2021 with Sri Ritesh Kumar Singh, thereby leasing to carry on the business of petrol pump of Messrs. BN Singh, petrol pump situated so and so, to monitor the entire trading and other activities of this admin. It is stated that herein that amongst other terms and conditions, the said lease agreement was valid from 1/4/2021 for a period of 3 years up to 31st March 2024. The informant further states that after expiry of the said lease agreement, Sri Ritesh Singh, in connivance with Raj Kishore Singh and his wife Muskan Singh, has manufactured that document later dated so and so. They have created they manufactured that document saying that it is being extended. And on that day, my lord, I was not in Duliajan also, my lord. In signature was false. I was in Delhi. I have mentioned in my objection, my lord, that tickets and everything regarding tickets and all. I was at Delhi on that day. On that day itself, they have manufactured it. So this is a fit case, my lord, where, my lord, such type proper investigation is required, my lord. If, my lord, they have been released on bail, my lord, there is every possibility to hamper or tamper with the evidences, and there is flight risk also, my lord, because the huge amount is involved, my lord. For another investigation, their presence is required. This is not a case where, my lord, bail should be granted, my lord. It is my respectful humble submission, my lord.
May I please, your lordship? Lordship may kindly come to page 92 of their affidavit. Page 92. even though Lordship, what my learned friend is saying is all coming to a point of basically a civil litigation where some dues are there. But Lordship, may kindly see the last paragraph, Lordship. And whereas the aforesaid liability is exclusively payable by the occupier second parties. Lordship, page 92. Page 92, Lordship, of the affidavit. Last paragraph, Lordship. And whereas the aforesaid liabilities exclusively payable by the occupier second parties, but they are not in position to pay the same. Accordingly, the first party and third party comes into a settlement, and the second party agree to sell their immovable properties, which the second party have agreed to sell their which standing in the name of the second party number 1 and 2, a residential plot measuring so and so, covered by dag number so and so, situated Sonapur, Namgarh Road, Duliajan town, Moza so and so, together with a Assam type house standing there, which is more described with in the schedule A below, which is approximate market value is not less than 30 lakhs. Further, a flat which is going to purchase by the second party number 3, so and so, a registered partner. Just the sum and substance of this paragraph is, Lordship, in lieu of whatever anomalies have happened, we have given them power of attorneys to our properties. Now, Lordship, as my learned friend is stating the FIR, now, Lordship, may kindly note the date, 9/6/2025 was the date when the FIR was lodged with regard to the alleged forged signature, which they are stating. Now, Lordship, if your Lordship may kindly peruse the title suit date, Lordship, that is at page 31 of my bail petition. Page 31, Lordship. Therein, Lordship, page 38, Lordship. 38. Page 38, Lordship. This affidavit, this case was filed, this petition was filed on 13th of May, Lordship.
Page 38.
38, Lordship.
38 is part of the plaint.
Yes, your Lordship. 38, point number 6, that till date the plaintiff invested an amount of rupees 4 crore 70 lakhs only in the same business, which has also been acknowledged by the defendant number 2 in writing by letter 11/3/24. Sent by the defendant number 2 to the plaintiff. Now, this is a document, Lordship. Why I am stating this? We have brought it out before the court. We have placed it before the court. If we had an intention to, and moreover, Lordship,
then only I came to know that there is a fourth document.
Moreover, Lordship,
So that I was not aware.
when we were intimated about the FIR being registered, we ourselves have submitted the document for necessary investigation. There is a seizure list, Lordship. We have ourselves submitted, Lordship. As my learned friend is saying that so many cases are pending, if we go on bail now, in this case, other cases will hamper. Lordship, these are the 335 3 notices, Lordship, where we have been constantly appearing before the investigating officer every fortnightly.
So the background is a lot of dispute.
Lordship. That is an admitted fact.
My lord, he was given for leave to run that petrol pump. He misappropriated a huge amount of fund. He unable to make the repayment as per the agreement. Then he started, my lord, this hue and cry havoc situation was created on that day, my lord. It was in media and all. And the target was to capture that petrol pump, my lord. And
it's bad if it's true.
My lord.
It is bad conduct if it's true.
So this is not a case, my lord, where, my lord, he should be enlarged on bail, my lord.
He's not in custody,
but we are cooperating with the investigating officers, Lordship.
Other cases are also pending, my lord. It is up to your lordship.
Lot of acrimony. I think, in my humble opinion, I think at this stage, since anything you want to say, learned purpose. It's going on.
As far as my lord, section 117.
That is prima facie. That's not coming. And
the other offense, my lord, with intimidation and my lord.
Apart from those aspects, I feel that since they are already on interim, I think making it absolute will, it'll not, it'll rather, it might help to mitigate the acrimony.
Conditions are required.
But I will impose conditions.
Lordship,
They are already in so much dispute. So now this might help.
Lordship.
It might be soothing. And so,
High objection may be recorded.
of course, you have been instructed, so you have made your submissions. That part we can take, because it was a repeat for a broken. 6/6/2025, first three paragraphs will be said. First of, on 6/6/2025, the petitioners were granted interim pre-arrest bail with conditions. In this regard, the learned counsel for the petitioners submits that in compliance with the same, they have cooperated with the investigation and appeared before the investigating officer, and their statements recorded and stuff. It is submitted by the learned petitioner counsel that the case has emanated largely out of a civil dispute pertaining to a petrol pump. And taken the court through some of the relevant documents according to him in this regard. The learned additional PP RJ Burra submits that case diary has been received, which reveals progress of investigation, semicolon. The statements of the petitioners have been reported, and the medical report with regard to the incident indicates simple injury caused by blunt weapon. Learned counsel, your good name, please.
A. Goel.
A. Goel, learned counsel, appears on behalf of the informant and objects to the grant of bail, and points out that other FIR has also been lodged against these petitioners. It is submitted by the learned counsel objecting to the bail that in the circumstances, because of the conduct of the petitioners, they may not be deserving of being granted bail. However, upon perusing the materials available at this stage and considering the submissions, prima facie it appears that the instant case has arisen in the backdrop of significant acrimony between the parties over running of petrol pump with allegations and counter allegations. One civil suit is also pending between the parties. One document allegedly extending the lease regarding the petrol pump is disputed by the informant side. Nevertheless, I'm of the considered view that seeing the progress of investigation and the cooperation rendered by the petitioners, making the interim bail absolute would be in the interest of justice, and it could also facilitate some resolution of their underlying disputes, which are prima facie civil in nature. In such view of the matter, the interim bail granted 6/6 is hereby made absolute, subject to the conditions that: number one, they shall cooperate with the process of law and shall not indulge in any illegal activities. Number two, they shall not in any manner cause any harassment, harm, or annoyance to the informant and his family members. They shall not hamper and tamper with evidence.
And jurisdiction also, my lord, shall not leave the jurisdiction.
So, well, actually, that causes some problems from my practical experience. Every time you have to come, unless there is a serious kind of financial
Here, my lord,
crimes where there is a flight risk.
2 crore 82 lakhs amount is involved. That's why huge amount is involved.
What I can say is that
Yes.
If they goes outside the
during investigation, outside the state,
if they goes outside the district or state,
outside the district.
inform the investigative officer.
Okay, that can be done.
That's
the petitioner shall intimate the investigating officer if they are going outside the state of Assam. Outside the state of Assam.
jurisdiction of Duliajan. They may. My lord,
That will be,
all.
because people's,
My-
that is also part of liberty side,
My-
movement,
Direct-
Duliajan is so, you may cross into Tinsukia. So it's all nearby.
Right.
From my practical experience,
Right,
this causes
absolutely.
problems
Absolutely correct.
within the state of Assam.
Yes, sir. All.
Deeply obliged,
Deeply,
Lordship.
deeply obliged.
Disposal.
May I please? This previous bail application, this one he is on interim bail. He is already, he is someone and he has already appeared before the IO and his statement has been recorded, my lord. The petitioner here.
Foreign
also-
cigarettes carrying,
Foreign cigarettes.
allegedly carrying foreign
Yes,
cigarettes.
the driver has carried the cigarettes in the coffee seats without his knowledge.
He's the driver.
No, he's the owner of the truck. my
Oh.
lord. The driver, he was arrested and he was already enlarged on bail. my lord. He has already appeared in his statement has been recorded.
You heard on the earlier occasion, right?
Yes, my lord.
I'm recollecting. Yes, Ms. Deka.
He appeared before the IO lordship. Till now, lordship, no involvement has been found, lordship. His
So far.
statement has been recorded, lordship. We have annexed in our affidavit, lordship. It is there on record, lordship.
Fair. Prosecution's duty is always to assist the court very fairly. So the judgments where says that even if something is there, which is in the favor of the defense, which is not come to their notice, you can, you have a different role, the prosecution. A larger role, actually. Anyway. So I think we should dispose it of.
It can maybe
Yeah,
improve.
you can also suggest, I will impose the standard conditions. If any specific condition you want to, I can consider, you can suggest. Let me dictate. In the process of dictation, you can suggest. It would, we can take from the order dated 10/6/2000, like we can save time in this first two paragraphs. Up to third paragraph, we can just, it will be identical. Mr. R. Shekhar, Learned Counsel, submits that pursuant to grant of interim bail on 10/6/25, the petitioner has appeared and his statement has been recorded. The petitioner is stated to be the owner of the truck, and his contention is that he was unaware of the carrying of poppy seeds of alleged poppy seeds of foreign origin and foreign cigarettes in violation of law by the driver. M. Deka, Learned Counsel for the DRS, appearing on behalf of Sikh Kyle, Learned Standing Counsel, drawing attention to the affidavit filed by the department in this regard, fairly submits that pursuant to grant of interim, his statement has been recorded. And so far, his involvement in the alleged offense has not been found. You have received the diary, right? His diary?
Earlier, lordship, we received case diary, lordship.
Now it's sent back. Huh?
Yes, lordship.
So you file the affidavit.
Yes, lordship.
So case diary, लिख बन रहा है. So in the circumstances, it would be just and fair to allow the bail petition. Accordingly, the interim bail granted by the order dated 10/6/2025 is hereby made absolute, subject to the conditions that he shall cooperate with the investigation, shall not hamper or tamper with evidence. He shall endeavor to ensure that the truck is under seizure.
Yes, Lord.
Oh, it's not released.
Market.
A third condition to null. He shall not hamper or tamper with evidence. Any other condition you want to suggest?
But the investigation.
That I have written. The bail petition stands allowed and disposed of by 4 sectors.
Very obliged.
33.
Services evident.
Also matter?
Okay, we have taken 2 times steps. Lord.
Okay. He's
So-
in jail since?
No, Lordship, we anticipate.
Oh, sorry.
Only prayer, Lordship.
Yeah.
On the next date fixed, Lordship, if the respondent will turn up. So, Lordship may appoint amicus curiae, Lordship, in this case. If next date.
I appreciate your summation, but the practice, as I understand, as I've seen this here, is that, you know, after service is complete, if nobody appears after service, then we definitely will appear. But at the same time, you know, matter should not remain stuck at the stage of service also for long. So can you take instruction to police? He will take the instruction to police. The matter is, the bail petition is pending for service of notice upon respond number 2/informant. Mr. Islam?
Yes, sir.
A. Sharma.
Yes, sir.
A. Sharma, Learned Counsel, submits that 2 dates have already elapsed for the same. So the DP Goswami, learned additional people, undertakes to take instructions regarding the service so that the bail matter can proceed ahead. Fixed on
1/9.
1/9, okay? 1/9.
If I read page 10, and your lordship will find wife was alleged to have been killed, that is the same.
Yeah.
But here the present petitioners are my father, mother, brother, and relatives. Husband number 1, actually page 10 you was kind to see, number 1 already arrested husband.
Rahman Mandal.
Yes, Hafizur Rahman Mandal. He is the husband already arrested, my lord. And he was arrested on 4/7/25. 4/7/25. Now, so far, my dear lordship, can see the date of occurrence is my lord, 8/6/25. And she died on 28/6/25.
8/6/25 is the
8/6/25 is allegation that she was assaulted.
I see.
Therefore, she was admitted in the hospital. So
And
different
died after a few
she
days.
died on 28.
After a few days.
28/6, but about after 20 days. Man.
I'll just go through the
But page 10. Humble submission is that about 10 years back. My marriage is 10 years back.
I'll read it myself. You know.
Constitution is not happily done, man. So,
Okay. This is the allegation.
now, my lord, she was about 20 days she was in hospital. Whether in dying declaration or anything is there, my lord, and what is that? My question, my lord, all these facts from your lordship can see petitioners, total petitioners are 5. Number 1, petitioner number 1 is a brother of accused number 1.
Okay. Brother.
Brother of accused number 1. And number 2 is the wife of accused petitioner number 1. Then number 3, mother of accused number 1 or petitioner number 1. Mother. And 4 and 5, they are the sister's husband and the sister.
Okay.
They are married. So I think, my lord, they have only because this type of cases normally all the family members have, my lord, normally got in the opinion, my lord. And then after 20 days, my lord, see that. Maybe.
We'll be able to segregate actually,
Yeah.
on the basis of the materials,
My lord.
ideally. Anyway, let us see what CDS come back.
If CD is available, my lord, the written part I have flag marked, my lord.
You can also submit initially and then I will look
Yes.
at it.
No, my lord, there is the PM report is not available, my lord. The PM report is available, but it is sent for chemical analysis. my lord, Because the using of poison is there, my lord.
Mhm.
One part is there.
Mm.
Secondly, my lord, here, my lord, the one in the, it is stated in the FIR is the regarding the dying declaration, my lord. That is all- that is-
Suicide note.
Yes, my lord, that is very clearly in the vernacular part, only the relevant part I am reading it out for your lordship.
Yeah.
That is the উল্লেখযোগ্য যে ছোৱালীজনীয়ে মৃত্যুৰ পূৰ্বে এখিলা কাগজত তাইৰ মৃত্যুৰ কাৰণে আসামীসকলক দায়ী বুলি লিখি থৈ গৈছে. So that is stated in the FIR, my lord. And even, my lord, that is the regarding that the delay part. That is the, my lord, that is the commission of the offense. That is took place when the incident happened on, my lord. That is 7/6/2025. And my lord, that is the relevant part of the vernacular part is page 16, my lord. Page 16 of the petition, my lord. May I read it only the relevant part, my lord?
Page 16 of the petition.
Page 16 of the petition, my lord.
Please
Page
read.
16 of the
Please,
petition, my lord.
please read.
Only relevant part, my lord. যোৱা 7/6/2025 ইংৰাজী তাৰিখে ঈদ থকা কাৰণে ঈদৰ পিছদিনা যোৱা 8/6/2025 ইংৰাজী তাৰিখে দুপৰীয়া অনুমান 12টামান বজাত মই ছোৱালীজনী নিজ ঘৰলৈ অহাৰ উদ্দেশ্যে 1 নং আসামী গৃহত প্ৰৱেশ কৰা মাত্ৰই দেখিবলৈ পাওঁ যে আসামীসকলে মোৰ ছোৱালীজনীক হত্যা কৰাৰ উদ্দেশ্যে বেয়াকৈ মাৰপিট কৰি শৰীৰত ৰক্তাক্ত জখম কৰিছে। আনকি ছোৱালীজনীক বলপূৰ্বকভাৱে ঘাঁহনি মৰা বিষ পান কৰাই দিয়ে। মই 1 নং আৰু 2 নং আসামীক বিষ খোৱাত বাধা দিয়াত বাকী আসামীসকলৰ সহযোগিতাত মোক ধাক্কা দি পেলাই দিয়ে আৰু বেয়া বেয়া ভাষাকৈ গালি দিয়ে। বৰফতলত মোৰ ছোৱালীজনী অচেতন। So that
Always, it should always be written at that distance. 46.
46, time being.
Yes.
In this case, in the morning I have checked whether CD is available or not, so
Oh,
DPS to check.
okay.
CD is available.
Oh, so this matter you
Yes.
mentioned. So now I can take up, I can take
We
up.
have to, we
There
have
was-
to go through the case diary also.
Yes, yes.
So, and my lord, I have also one small typographical mistake has been committed in the name of the petitioner's father, my lord.
Mhm.
So, my lord, can it be corrected, my lord, or I have to file an IM, my lord, for this, my lord? Just
Can be
instead of Kadir, it should be Karim, my lord.
If it's permissible as per our practice and directions, it can, you have to file an I. So
Yes.
for, it's not allowed.
Yes.
I don't know.
I'll
As
make
per
a-
the practice direction,
My lord, my lord.
I have.
I have to file an I. Oh,
Day after tomorrow. my
if that
lord.
is the practice
Yeah.
direction now, here. And you
Day
file
after
a short
tomorrow,
I,
We
huh?
are retaining the CD day after tomorrow.
Day
You
after
file a
tomorrow.
short I,
Yes.
quickly allow.
Yes, tomorrow.
And you also get some time to go through
Yes.
tomorrow?
Okay, I will file tomorrow. Okay, my lord, well, I'll make a mention in the morning, my lord, for listing of that IM, my lord. Or day after tomorrow.
No, let it be tomorrow only. You know,
Yes,
day
tomorrow.
after tomorrow, I myself might have some
Yes, ma'am.
constraints because
Tomorrow,
I'm,
ma'am. Tomorrow.
I'll be unavailable next 2 weeks.
Yes, madam. Madam.
So I
Tomorrow,
have to
ma'am.
finish some
Yes, ma'am. Tomorrow.
matters. So let us keep it for tomorrow.
Right, ma'am. Okay. Obliged.
Stop. The learned counsel submits that he may have to file an IA for correcting a typographical error. The case diary has been received. Fixed on
21.
21.
Obliged, ma'am.
Clear.
45,
45 also service is limited.
Awaited.
In that case, interim, bail moving.
So for is there.
Interim,
Wait for a service also.
usually it is.
In the meantime, I can take instruction whether the service is completed.
Please take instruction because I don't know the facts also. I can see the Azhar.
The case is that
Obviously, the allegations.
Yes.
But if Lordship says the other, the incident occurred on 23/1/25. And the FIR was registered on 6/2/25, Lordship.
Is it?
And Lordship, there is a clarification, Lordship.
Azahar is dated 29/1 as per
But
your
it
type
is-
copy.
It was registered on 6/2, Lordship. Page number
No,
10.
date of the Azahar is relevant as you.
Here also, Lordship, on 23rd incident has occurred and they have lost the FIR on 29.
3 days, 6 days delay.
Yes, Lordship.
So we'll take the instruction which was submitted completed now, they that, may appoint and I find out. It's not completed.
Interim pair may be considered.
Not at this stage. Just hold on. We'll dispose it of hopefully when that comes. TCR has come. It's at a stage of.
In case there is here.
Okay, sorry. It has been received?
Yes.
Okay, no problem. The learned additional PP undertakes to take instructions regarding service of notice upon the informant. The case diary has already been received. Stop. Fixed on. When should I fix it? Short days.
First of 19.
19.
Lordship
19
can fix it in earlier date.
earlier.
Earlier yesterday is 29 then. 29, 28.
29.
46.
Obliged, Lordship.
Yeah, please allow you. In this case, the sheet has been filed, my lord, I should know.
What are the sections?
So many sections, my lord, the dispute, my lord, regarding the land dispute between the same family, my lord. And petitioner is in, my lord, interim protection by this honorable court. He has already been appeared and cooperating with the police investigation authority, my lord. Process of hearing is.
Serious injuries.
Process of-
So I can dispose it of. Violence. Go, I'll give the lower part. Yeah, it's there. Mr.
T Sheikh, my lord.
T6. Learned Counsel submits that in the meantime, investigation is completed, resulting in a charge sheet. And pursuant to direction of pursuant to grant of interim bail on 5/8/2025, the petitioner has also appeared before the IO. The statement records. The learned additional PP confirms that the charge sheet has been submitted. In the circumstances, the interim bail granted by order dated 5/8/25 is hereby made absolute, subject to the conditions that the petitioner shall be available for the trial, if one commences against him, and he shall not hamper or tamper with evidence. Bail petition stands allowed and disposed of.
Highly obliged.
Supplementary bail hearing 2.
This case, private party files an objection also, my lord. We received it, it may be in the file. Your lordship will find page 13, madam, vernacular, your FIR.
Informant has appeared, no? You have appeared. No, private counsel, not amicus, right? Yes, sir. Which one?
The objection was page 13, your lord's kind of FIR, man. Vernacular, my English translation is not, my lord.
No, you can, no problem.
Yes.
We can read.
9.
You can read the vernacular also, no problem.
Yes.
That is better, in fact.
It does do better.
Attempt.
Attempt.
Service is complete upon respond number 2. However, There's neither ID card nor unserved notice or service report is stated to have been received back with regard to respond number 3. Any submission or suggestion from your side? Formal party we can,
Yes.
perhaps. It is submitted that it is submitted by learned counsel for the petitioner that perhaps presumption of service can be drawn as the communication was sent by registered post with AD on 3/4. On you sent it 1 month back. You must have sent it 1 month back, 3/4 to 2025. Therefore, what was that provision? I keep forgetting. 9
That is
something
section
of
20.
General Clauses Act.
General Clauses, section 27. 27 of the General Clause.
No, there's another one. No, 27 and 9 something. When it is sent by registered post and it doesn't come.
Section where any of the any or regulation made after the commencement of this act authorizes and or requires any document to be served by post, whether the expression serve or either of the expression gave or send or any other expression is used, then unless a different intention appears, the service shall be deemed to be affected by properly addressing, prepaying, and posting by registered post a letter containing the documents, and unless the contrary is proved to have been affected at the time of which at which the letter would be delivered to
General Clauses Act,
in the ordinary course of post.
General Clauses Act.
That is the section 27 of the General Clause.
9, what is 9, section 9? Just 9 some. General Clauses Act. Anyway, we'll not waste time, but
in any central regulation.
no, 9(2) or something, 9 subsect clause 2, something of that.
This section applies to all the central acts made after the 3rd day of the January 1968.
Sorry.
1868.
I may be mistaken. Anyway, so therefore, in terms of the relevant provisions of the General Clauses Act, the service upon respond number 3 is deemed to be served. Can TCR is already received?
TCR has not been received.
It is received? Oh, I thought it's made that submission.
Okay. Yes.
Oh, sorry, it has not been received. No, not yet received. Should we issue a reminder?
No,
Issue a reminder. List after receipt of the scan TCR.
A date may be fixed after 2 weeks.
In the last week of September on 24/9.
Much.
Orders. Hold on. And finish it quickly.
Yeah, it may be now. My lord, in this case, notice has not been served up in respond number 2.
True. We'll wait.
Yeah.
Wait for some time. Service upon respond number 2 is awaited. Stop.
My lord, fresh notice may be issued.
The petitioner shall take fresh steps of notice upon respond number 2.
My lord, I may be allowed to take a step through registered post.
Upon respond number 2 by registered post. List after
Last part of September.
Last week of September. On 24/9, sorry, 24/9, right?
My lord,
Next. Orders can be put established. Oh, yeah, 5 minutes. There's a meeting actually, so to 4 o'clock. Noble Chief has come, all of us try to finish. Yes.
We have appeared one. I filed my Bakalatnama yesterday, Lord.
Okay. For R2,
For
respond.
R2, for respond number 2.
Okay. So, record is here. Record has come.
No, record is not visible.
It has to be procured.
Record is to be
Lordship,
called for.
The complaint petition, Lordship, only their grievance is that the notice has been issued to the accused person without the examination of the complainant, and cognizance ought not to have it.
In terms of the new law,
But in terms of the new
New
law,
law.
it is a pre-cognizance stage,
hearing.
pre-cognizance hearing which has to take place, Lordship. That is the
Okay.
only thing.
Records may not be necessary, according to you.
Records otherwise may not be necessary in this case, Lordship. Only the complaint
Okay, we
petition
can
that
take a
has been
chance.
annexed.
Sir?
Get this stay order, my lord, it may
Okay.
continue.
It may continue. So we can take a chance to dispose of without records.
Yes, yes.
If-
Yeah, up to your lord.
If we run into difficulty, then we
Yes.
can call.
Yes, yes. A short date may be given, Lordship.
Your good name?
A. Ganguly.
A. Ganguly. It's been many years. Learned counsel appears for respond number 2. The interim order shall continue till the next date of listing. Fixed on 19/9. Right?
It be
Indeed.
a bit earlier, Lordship. First or
It's all packed, trust me. Otherwise, why will I not give? 19/9, even.
43.
Yes, please.
In this matter, service is awaited, your lord.
Service is awaited.
Yes.
Uh,
There, so.
Okay, we'll wait or you want
Yes.
to take fresh steps?
No,
No.
wait.
Service upon respond number 2 is awaited. List after 4 weeks.
Last week of September, if possible. your
Oh,
lord.
yes, it's last week of September. Is a criminal petition. Fix last day, it's will be very, very crowded. It may be. Fix on 24/9.
Much obliged.
Before a year after my learned friend appeared for respondent. He appeared for the private respondent number.
Criminal petition.
Can be was called for, will it come?
I'll just check. Not yet received. We'll issue a reminder. Issue reminder for the scan TCR. Sri B.M. Chaudhary, assisted by U. Chaudhary, enters appearance on behalf of respond number 2. Should we fix it in September last week or later?
As you lordship, please.
Fixed on.
Can it be, my lord, because the trial, my lord, some other accused are also there.
So you have some urgency. 5/9.
My lord.
5/9.
Obliged, lordship.
Supply 2. এইকেইটা হেৰিত আহিব বোধে
54.
শিবু এইকেইটা অৰ্ডাৰ্ছত আহিব বোধে এডমিশ্যনত আহিব এইটো এডমিশ্যনত আহিব বোধে will come in admission বোধে এডমিশ্যনত আহিব
54.
Lordship.
last one.
Lordship, this is for a modification of a bail orders.
Is it
Lordship, the interim order will Lordship find at page 63.
okay? The said learned judges available.
She is not here anymore, Lordship.
Madam
Not-
Madam Nandi.
Madam Nandi. Lordship.
Then
Lordship, what has happened,
I
that
can take
another co-accused Lordship, just now I had moved a similar application before court number 14. And that was allowed, Lordship. So otherwise, Lordship,
Oh, you have-
modification
if
of
there's
the-
any error, typo error on our part, you have.
Lordship, I'm seeking a relaxation of the paragraph 6 subclause A of the order.
Oh, you want that kind of modification?
Yes, yes. No, that I cannot leave the territorial jurisdiction of Kamrup Metro. So my lord, there is direction that I cannot leave the territorial jurisdiction of Kamrup Metro without the permission of the CGM Kamrup Metro. Now, my lord, I'm a resident of Silapur, Chhattisgarh, and I'm working there. So my lord, every week, every 3 months, I have to come to Guwahati seeking permission from the.
I was just saying, it causes more work for us. Anyway,
My lord.
but I have to hear the prosecution.
My lord.
For some. Unless the situation really demands No, that's why I would not.
Moreover, my lord, 3 years
Oh,
is passed.
I don't know what is the facts of this case.
My lord, 3 years is passed, charge sheet has also not been filed so far. Every time, my lord, we have appealed for 10 times, ever since we were granted bail, my lord.
What is the order?
My lord,
Take me to the order.
363.
420, 406, 120, and 40 and 468 IPC.
Page 63.
My lord, 63.
The interlocutory application has been filed by the applicant Nitin Singh,
Yes, my lord.
seeking modification of one of the bail conditions imposed by the order dated 22/6/2023, whereby he was granted regular bail
Yes, my lord.
in connection with Alton Bazar PS case number 272 of 2022 under section 420, 406, 120B, 408, 468 IPC. Three conditions were imposed. Three bail conditions were imposed. And condition 6A was that लिखिए उठा दियो so and so. It is your good name, please.
S. Mitra, my lord.
S.
S. Mitra.
S. Mitra, Learned Counsel submits that the petitioner, being a resident of Bilaspur, Chhattisgarh, he's a businessman.
No, my lord, he's a serviceman. He is working with NetAmbi Google Pay.
Such a condition is causing him practical difficulties and seeks modification of the same. The Learned Counsel submits that the learned judge who had passed the said order has already retired. Heard DP Goswami, learned additional people. What do you say?
When you approach, when a person approach the trial court, relief petition, then regularly they have extended, the trial court extended the prayer. So if they leave it granted 3 months, then thereafter 6 months, already extended the prayer of relieving lordship.
10 times, my lord, I have appeared till date.
Generally,
every date, my lord, I am personally present here before the learned senior. Including today also, my lord, I am personally present before the learned senior. My lord, we impose any other condition?
Upon considering the matter, I find force in the contention of the petitioner side that the petitioner, being a resident of the state of Chhattisgarh, bail condition 6A has caused him some practical difficulties, as every time he has to seek written permission from the said learned court. Next paragraph, needless to say that free movement of a citizen across the length and breadth of the country is also a constitutional right, constitutional and human right, constitutional right of the person, and that is also applicable to a person on bail, unless there are circumstances which would justify restricting his movements within a certain area preventing him from going abroad. That's all. Therefore, I'm inclined to modify that condition. Modify the said condition. Thus, new bail conditions enumerated in para 6 of the bail order dated 22/6/2023 shall read as under: the petitioner shall not, he is a service holder, he shall not abscond. The petitioner shall cooperate with the remaining investigation. Petitioner shall not hamper or tamper with evidence or make any attempts to influence witnesses. You can suggest about this. In lieu of this, what conditions can be imposed?
In the order annexed here, Lordship, it is reflected that the petitioner is appeared continuously after the, so is considering his conduct also in order annexed here, Lordship, and
This will suffice.
no, the thing is that investigation process going on, Lordship, charge is not submitted. As required, he has to.
As in,
provide the investigation.
Okay. And next, the petitioner shall be available for trial in the event of charge sheet being filed and trial commencing against it. The IS stands allowed and disposed of on the aforesaid terms.
Grateful, my lord. Obliged.
So I think lots are left. Admission I could not touch.
Item number 9, my lord.
I was planning to try and dispose one or two, but there's a meeting, so I'm already late. But
Only one payment.
we can join.
Interim order be extended, my, that's all.
Where?
Item number 9, interim order be extended, not will fix a date, my friend is appearing for the response.
Only that matter? Only only 9?
If I may submit one thing,
Uh,
there are, in the complaint case matter, there are 4 accused persons, only one person have approached this court, but this whole proceeding has been stayed, my lord.
Okay. I see.
Can I make a?
When is the order of stay? I've stayed
No.
earlier.
Earlier order,
Yeah,
say, Lordship will can the stay and fix a date for you.
That is ordered dated, my lord, 14/11/24.
I see. And now though it has to be extended since
Yes.
we cannot, it will be extended.
Short date maybe.
Okay. The interim order will be extended. Item
9.
9. It will be extended. And what else? It is at the stage of admission. It will remain in admission, or should we fix it for your admission?
Fix a date.
I only pay for short date, only because the whole
No.
proceeding has been stayed.
Any day, my lord, except 2nd of September, my lord, I'm ready.
It will be later than that. You fix many matters. Take it on 17th September.
Lordship.
Regarding item number 13, madam, can it be taken up on Friday, my lord? There is no interim, madam, then lower court is proceeding with the matter.
Okay. It's a criminal petition.
Criminal petition, madam.
We can try.
Friday, madam.
We can try.
Right.
It's Friday, there'll be some,
Yes.
because I'll be unavailable next 2 weeks.
Yes.
So there
On
might be
Friday,
some,
madam.
I may also have some work to complete.
We'll take a chance on Friday.
We'll
madam.
take a chance. We can take a chance. We
Right.
can try a chance.
Right.
Item, we just
13, madam.
13, have to carefully look it over.
Fine.
Date may be given, Lord.
Did you update it? Last week of September?
Lordship, item number 12, I need date.
You want a date?
Yeah.
Last week of September will do. Any interim order? No.
No.
Last week of September, early part of last week of September, let it be on 22nd September. 22nd
do.
September.
Maybe.
Last week.
Lordship, I beg to mention item number 8. Lordship, on last occasion, it could not be taken up because of paucity of time.
Yes.
Lordship, can it be on next week, Lordship?
Next week.
Lordship.
Yeah, it can be. It can be on.
Any date on next week, Lordship. Because the trial is proceeding.
Yeah, so you remember. Next week. Take it on 29th. 29th. If hearing is concluded, weekend is there. I can write also, if not dictated in court.
Lordship.
Or you want earlier? 29th is okay.
Can it be earlier, Lordship?
That week only.
Because this matter will not take your Lordship so much
Much time. 27?
Lordship.
27.
Always.